Do you have Detective Newman for the witness stand? Okay, let's put Detective Newman back on the witness stand. Well, actually, you can't just have him come into the courtroom because he's going to need to be resworn. Any other issues to address before we get restarted?
None for the state.
In the defense?
Not at this time.
Okay, very good. Have you all communicated further about your scheduling if necessary, or?
There are some wheels turning.
Okay,
We're going to have to take a deposition during the lunch break
okay.
if Esquire is available.
But that would be me.
Okay, I didn't know if you had somebody else that could relieve you.
No, I don't, unfortunately. Wow, okay.
Alternatively, I think that we could maybe do it this afternoon. I just won't have time to get a transcript done.
Okay, well, just let me know. We'll address it. We have the jurors? They're on the way up, okay. Let me go off the record momentarily. All right, good morning, ladies and gentlemen of the jury. It's always my custom, particularly in cases such as this that are high-profile cases, even though I know I sound like a broken record, to always remind you the beginning and the end of court session. Make sure you don't get exposed to any extrajudicial information about the case. Don't talk to anyone, including your fellow jurors, about the case. Don't do any research about the case, and avoid all media reports of the case. We're going to continue where we left off yesterday. And Detective Newman, if you could come forward and be resworn for today's court session and take the stand, we'll continue with your direct examination.
Do you swear or affirm that the evidence you're about to give will be the truth, the whole truth, and nothing but the truth?
I swear.
Thank you.
And you may inquire of Detective Newman.
Good morning.
Good morning, sir.
Just for the record, state your name again, spell it.
Christopher Newman. Last name is Newman.
All right, we wrapped up yesterday with the defendant's interview.
Yes, sir.
Okay, and as part of speaking to the defendant, did you learn that he was married at the time of this case?
Yes.
Okay, who was he married to?
Debbie Escalera.
Okay, and as part of your investigation, do you also then interview other people that may know potential suspects or witnesses in the case?
Absolutely.
And does part of your investigation also then involve doing subpoenas or issuing search warrants for phone records?
Yes, sir.
Okay, and as part of your investigation, did you obtain, and I know you asked in the interview, you asked the defendant for his phone number. Did you also get the victim's phone number in this case?
Yes.
Okay, and did you also get Deborah Soto-Escalera's phone number?
Yes, we did.
Okay, do you recall what her phone number was?
I believe it's 989.
And for now, I don't have any other questions. Thank you, Detective Newman.
Thank you.
You're welcome.
During your interview with my client, he consented to give a sample of his DNA, correct?
Yes, ma'am. Good morning.
I'm sorry?
I said yes, ma'am. Good morning.
Good morning. And he also consented to a search of his phone, is that right?
Yes, ma'am.
Okay. And he also consented to a search of his truck, is that right?
Yes, ma'am.
Okay, and you let him leave with the truck
Yes,
after
ma'am.
the search?
Yes, ma'am.
So he took it home.
Yes, ma'am.
And during the course of your investigation, you talked a little bit with the state about that. You learned that Tania was also seeing somebody by the name of Bradley Rodriguez, right?
Yes, ma'am.
And you learned that Tania's mother, Tania actually lived with her mother and Bradley Rodriguez, right?
I'm sorry. Can you repeat that?
Bradley and Tania lived at Tania's mother's house.
Yes, ma'am. Briefly.
Okay, and that Bradley was kicked out of Tania's mother's house in March of 2018 because Bradley was violent with Tania.
Yes.
And you learned that Bradley was possibly one of the fathers, correct?
Yes, ma'am.
You also learned that there was another potential father of the baby by the name of Mark Burke, correct?
Yes, ma'am.
And you learned through the course of your investigation that Mark Burke actually had a turbulent relationship with Miss Wise, is that correct?
As I recall, yes, ma'am.
And that he had actually abused her and was arrested, correct?
I don't recall if he was arrested for abuse. I can't recall that, ma'am.
Okay, if I showed you your supplemental report, would it refresh your recollection?
Yes, ma'am.
Okay.
Your Honor, I'm not object at this point for the approach.
Jury, let me ask you to please step back into the jury room. There's an issue you need to address out of your presence. Please don't discuss the case with each other. We'll be with you momentarily. Jury has exited. Just so I can clarify where I'm coming to, also, this is not directly in reference to what we were discussing at the bench, but I did give this some thought at some point during the trial that the reason I would allow this to, it's much like if it's reverse Williams rule. If the roles were reversed, domestic violence, killing, the history between the parties, it becomes admissible. So, who wanted to inquire of the detective on this point as far as whether there's a public record as far as that
I
arrest?
just ran Mark Burke with his date of birth for his CCIS, and I don't see any arrest for domestic violence or misdemeanor battery.
Since the jury's out, Detective Newman, what they're trying to figure out is, in your report, apparently, you had some information about that person being arrested for domestic violence. We were trying to distinguish whether that was based on hearsay that somebody told you, whether there's actually a public record of the arrest that you discovered in your investigation, if you know that off the top of your head, which you probably don't based on what you previously said. But that's what they're trying to figure out.
I'm sorry, Your Honor, I don't recall that. I remember there was a fraud case from Port St. Lucie
Right.
that we actually had a report number from. I don't recall any domestic violence getting a report for anything for that, so.
I've seen the fraud case, and it looks like it was one of us.
So with that, anything else on the proffer? I would sustain the objection because it does look like it's based on hearsay and there's no actual basis for his personal knowledge as far as there being an actual arrest in that regard.
Judge, can I, at the time
Sure.
during your investigation, Mark Burke was under charges, had been arrested for charges with Tania for a fraud case?
Yes, and I can't recall the case number, but I believe we did get a copy of that. I think it was Port St. Lucie Police that did the case on that.
And they were co-defendants.
I believe they were co-defendants, yes, ma'am.
Did you learn during your investigation that Tania was afraid of Mark Burke because of that case?
There might have been people saying that, but with the amount of contact she was still having with him and meeting up with him when he still had an active warrant, I didn't really take that as she was afraid of him.
No, I don't want you to misinterpret what I was saying. If you wanted to ask him about that situation,
Yes.
I'm not precluding that because
Yes.
that's a separate motive situation. I just didn't want something to come in that was hearsay of an arrest that didn't happen through the other domestic violence arrest. So I'm not precluding that.
Yes, sir.
And the state's objection wasn't to that. But just to be sure, I don't know if you heard that, there's, as far as the arrest with regard to the fraud situation, that being a separate motive, I'm not precluding that.
Well, and I guess my question about, because I'm looking at the fraud case, and it says that Mark Burke wasn't even arrested on a warrant in the fraud case until August 27, 2018. So she's already murdered by the time he's arrested.
But he knew that the arrest warrant was out based on the evidence he was hiding out at Tomlinson's.
Or there's an
house.
inference that he knew of the global situation and its
Right.
possible motive involved.
Right.
Yeah.
Oh, I mean, there's no evidence of that that's been introduced in this trial so far, but.
He's about to introduce it.
Right. All right, so, but the original objection was to the domestic violence arrest, which we've covered. There is no such arrest. So I'll sustain the objection as far as hearsay on that. It appears to be erroneous hearsay information from somebody else. All right, so I think we've at least made some headway clarifying where we are, right?
Yes,
Well,
sir.
Okay.
And I guess, so when I redirect him, are we permitted then to be like, so is there some domestic violence arrest between Mark Burke that you're aware of between him and the victim? And he's gonna say no. Because now the jury thinks that they got sent out of the room after she
Well,
asked this question.
that's up to you. I could instruct them to disregard the question, because he didn't answer it in the affirmative, he said, I don't know.
I know, but
Yeah, that's up to you.
my concern is obviously the appearance of objection, get sent out of the
It's
room.
just part of standard
All right.
litigation trial stuff that happens.
We'll address what we're gonna
Right,
do then when
right.
we. get our chance
Otherwise,
to-
you're left with the argument that there's no evidence of that, there was just the question. The classic voir dire that I've heard 1,000 times where, didn't I prosecute you for, I think this is your own voir dire. Didn't I prosecute you for this the other day? No, you didn't. That's the question versus the answer. All right, let's bring in the jury and we'll continue. And Detective, if you could scoot closer to the microphone as well, jurors may have some difficulty hearing you. Please continue your cross-examination.
Thank you, Judge.
You're welcome.
Sir, in the course of your investigation, you learned that Mark Burke had an active arrest warrant at the date of the murder for a fraud case, is that correct?
Yes, ma'am.
And that his co-defendant in that case was actually Tania Wise?
Yes, ma'am.
Okay. And that Miss Wise was afraid of him because of that case, is that correct?
Well, there had been people that had said that, but she had had numerous contacts with him after he had an active warrant, and she never turned him in and met with him on a regular basis, so I didn't know how afraid of him she was.
Okay, and when was the last time she had seen Mark Burke, to your knowledge?
I believe when I interviewed Mr. Burke, he said it was the week of her disappearance, and she had performed oral sex on him in his car.
Okay, and I think during your direct with the state that you said Miss Wise had been talking to a person by the name of Giovanni Alvarado, that you learned that, is that correct?
Yes, ma'am.
Okay, and actually she was supposed to, on the night of her murder, meet up with Giovanni Alvarado, is that correct?
That's what several people were saying, yes, ma'am.
Okay, and that during the course of your investigation, you also learned that a gentleman by the name of Jared Christie had dropped her off at her mother's house on the night of her murder, is that correct?
That would be, because that was Mr. Casino, right?
Correct. He goes by the street name Casino, but his
Yes, ma'am.
legal name is Jared Christie.
Yes, ma'am.
Okay. And during the course of your investigation, you got a DNA sample from Bradley Rodriguez Jr., is that correct?
Yes, ma'am.
And you got a sample of DNA from Giovanni Alvarado, correct?
I believe so, yes, ma'am.
And you got a DNA sample from Mark Burke, correct?
Yes, ma'am.
And did you get a DNA sample from Jared Christie, too?
I don't recall.
Okay, you don't remember if you got that one?
No, ma'am.
I have no further questions for this witness.
No questions. Subject to recall.
Thank you, Detective Newman. You may step down. You're subject to recall by the attorneys. Please make sure they have contact information for you. And the state's next witness or item of evidence.
Yes, sir. The people of the state of Florida call, excuse me, Agent Kelly D.P. Trantonio.
Ladies and gentlemen of the jury, there's another issue we need to address out of your presence. Please proceed to the jury room. Don't talk to each other. Make yourself comfortable in there, and we'll be with you as soon as we can. Don't talk about the case. All right, so Ms. Minton's going to look at the thumb drive to be sure it has the contents that were agreed upon. It may have other matters in that we're being abundantly cautious in that regard, taking the extra step to make sure there's no error introduced in the trial by inadvertently introducing something that wasn't intended. It's gonna take some time to do that. Should we take a break while you do that, or stay on the record? Being on the record might put more pressure on you with the, right?
Thank you, Judge.
Sure,
Yes,
we'll,
we
we'll
did
go
take a
off the
break.
record and give you some time. Just let me know when you're ready. Everyone, cell phone records of the victim and of the defendant, is that right?
Allegedly.
Okay, allegedly.
So we'll start with the T-Mobile records first. In the T-Mobile records, there.
Hold on a second, we have the cadet issue here. How many cadets do we have like this?
31, sir.
Okay. And what do you think of, when the defense had an objection to them coming in, but I don't know if you do, now that you see what they look like, I'm not sure you would associate that with law enforcement. They look more like a, no offense, they look more like a church group to me. So no problem with them coming in? Just look like students. I could even tell the jury that the people you see in the back are just students coming for educational purposes, if that makes you feel better. They're just wearing a shirt for the record
I
that's
think
like,
it's gonna be all right, Judge. Do
Okay.
you know how long these young people will be with us today?
they usually stay for an hour or two, right?
Yes, there'll be one more class, but they will not be dressed this way. They'll be in civilian attire.
Oh, okay, great, okay.
Thank you.
Thank you. Yeah, so you can come in, that's fine.
Yes, Judge.
Thank you. They've come in before. This gentleman here is the teacher. He's come in
Thanks, Judge.
before other trials. All right, so back to our business on the item in evidence, Ms. Minton.
Judge, I just realized that the witness through whom these records are gonna come in through is in the courtroom. I'd ask that she be excused from the courtroom for this portion of the legal
Okay,
argument.
pursuant to the rule. If you could just step outside for a minute, we may need to have you come in momentarily though, so don't go far.
Right. So in the folder that's labeled T-Mobile records, in that folder, there are subpoenas, which are not admissible, I do not think, regarding these phone records. I don't understand the utility of putting that in, nor do I think that that is necessarily something that's a business record certification or something that was noticed on a business record certification that a subpoena is coming in, signed by a judge. Then there are other items in this folder. So there's something labeled, and I apologize for the record, it's labeled SUB_TIBCO_ 772-607-0257 _5545494. This is information provided to agency sheriff requester Andrew Belanca. And then it goes through subscriber details, and it says Bradley Rodriguez. So that's another individual subscriber information, not the information of the alleged victim.
Well, just in brief response, Ms. Bedolla testified that Tania Wise was, her phone was paid for by Bradley Rodriguez. That's the testimony that's before the jury right now.
I do recall that someone testifying to that.
I do recall that, Judge, but again, it has his name on here. I just need to note for the record that I'm contemporaneously making these legal arguments without benefit of, good reflection or legal research whatsoever, because the first time that I'm hearing about the state wants to introduce these items into evidence was literally 10 minutes ago in a capital murder case.
Actually, that's not true. The state filed a notice of business records, notice to introduce business records on March 1st of 2021. And these records are in State Attorney Media 64, which is found on the 42nd supplement of the state's discovery, which was also filed and provided to the defense on March 1st of 2021. So all of these items, an identical copy, have been available to them in their possession since March of 2021.
And Judge, I think we're up to 90, we just got a supplement yesterday during the trial. I think we're up to properly numbered, there was incorrect numbering. I think we're up to 92 supplements, incorrectly numbered. I think properly numbered, we're up to 95. There are thousands and thousands and thousands, would not be an understatement, of pages of digital discovery in this case. just because the state files a notice of introduction of business records, I do not know exactly what they are going to introduce. They have not told me, again, they did tell me with the transcript translations, we are going to introduce these 2 items, please provide your redactions, which is the standard course of conduct in our circuit if you would like to introduce a piece of evidence that's not easily, I guess, debatable, like a picture.
Let me just interrupt you. I have an idea that might be productive. First of all, for legal purposes, I'll consider this, no pun intended, a Richardson hearing. Mr. Richardson. I don't find a discovery violation, but I think we have a practical problem here as expressed by Ms. Minton. She didn't see it coming even though it was disclosed. So maybe what if you proffered the testimony of the witness as far as what the state is intending to do? Because I have a feeling that everything, this document, if it's voluminous, this thumb drive, it probably contains a whole bunch of surplusage that is not relevant to her testimony. It's just putting in because it's, and then you'll know what it is, and then maybe we can hone in on, for everyone's purposes. I'm not sure it really helps the state's cause to throw a thumb drive back there with the Encyclopedia Britannica. If there's something that the state wants to focus on in the records, you could highlight that, and if it goes into the record just to, because it's what you have, that may solve the problem. I think on both sides I can understand the defense hesitation, but there's a lot of presumption on my part as far as what the witness is going to testify to. And I can't imagine that that's going to be a shock to the defense as far as the substance of what's in there. Right. So we want to do that? You want to just bring her in and proffer it and see what the item does as far as in the mix?
Yes, sir. But as a basic premise, can we agree that subpoenas, emails back and forth between the law enforcement agency and the provider are not admissible evidence?
What I was going to suggest there is, depending on where the road took us in the proffer, if there's, how many entries are you going to highlight with the witness, just approximately?
Yeah, so
Because what I was going to say is, if it was a limited amount, could you perhaps cull out, C-U-L-L out, from those, the items that you're focusing on, maybe print them out and have them, I think that's better for everybody. It avoids the defense problem and it highlights what the state thinks is important as opposed to the Encyclopedia Britannica on a thumb drive.
correct, and that's exactly what the state's going to do. That is the raw data.
Mm-hmm.
And the state, and Ms. DP Trantonio has provided Exhibit 148,
Mm-hmm.
which is a
Summary?
summary of that, which has the particular data in it that she is relying on.
Okay, so then my suggestion would be, what if you just had her refer to the thumb drive, is that's globally where she gets the summary. You don't put the thumb drive in evidence, you have to worry about the jury looking in the thumb drive and we're all good to go.
I have no disagreement with that.
Is that a good plan?
That works. Yes, sir.
Okay, if you got a summary and it's an official summary from her, I think that's better for both sides, it avoids the problem.
Right. And I also filed a notice of intent to introduce summary evidence with this specific exhibit on August 15th of 2025. So this is no surprise to anyone.
Right.
And that's why I thought that's what they were introducing
Understood.
and not the thumb drive.
But I think I
Okay.
cut to the chase practically, logistically for both sides, where we've cleaned it up.
Sure, yes, sir.
Better for the state, better for the defense.
That works. Yes, sir.
All right, so we don't need to proffer Miss D, I wrote it down phonetically here, D.P. Trantonio. The funny thing I was discussing with the lawyers for everyone else here is, there's a witness that's testified before me all the time. Her name is D. Pantronio. And Mr. Richardson said D. Pantronio. I thought he was mispronouncing it, and a different person walked in. It's a different person. So we have that on top of everything else. All right, let's, so you're all good with bringing in the jury, and I can't remember where we got, she didn't get up to the part where she was sworn. I think she didn't get past.
Right.
Okay.
She has not been sworn.
All right, so she's in the hall. Let's bring in the jury, and you can recall her, and we'll go from there. Jury is present, and you may proceed with your next witness.
Yes, sir. South Florida call Agent Kelly D.T. Trantonio.
Now, if you could raise your right hand and face the clerk.
You swear affirm that evidence you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Hand over to the witness, please.
And you may inquire of the witness.
Good morning.
Good morning.
Can you state your name for the record and spell your last name, please?
My name is Kelly D. Pietrantonio, Dipietrantronio.
Okay. And Ms. Deepan, what do you do for a living?
I'm a special agent with the FBI.
Okay. And can you give us a thumbnail sketch of your education, your training, and your experience, please?
Sure. I have a Bachelor's of Arts and a Master's of Science from Long Island University. After becoming an agent, or before becoming an agent, I went to Quantico, Virginia, and did my 20-week training to become an agent there. I'm also part of the FBI's Cellular Analysis Survey Team, or CAST as we call it, C-A-S-T. And to become a CAST certified agent, you have to, just like anything else that you don't know what you're doing, you start with a basic class, very simple. It's about a 2-day class, and we learn about the different providers. When I say providers, I'm talking about AT&T, T-Mobile, Verizon, US Cellular. And they show us the records that they maintain, why they maintain them, how they maintain them, what they look like. And then we figure out all of those records, and we figure out a way to actually plot those on a map so you can visually see where these phones possibly were when they were making a phone call or sending a text message or initiating a data session. After the basic class, you're paired up with a mentor, and you go back to the field, you work your cases, you practice some of these records on your own. Then you can get invited to the advanced class. And that's just like the basic, but just a little more nuanced. You learn Google, Facebook, Snapchat, car records, very similar to how you can track a phone, you can track a vehicle. So we work with all of those. And then if you do well, again, in advanced, you continue working with that mentor, you go back to the field, you work on those cases and practice working with those records. After that, you can get invited to what's called CIRA. That's the Critical Incident Readiness Assessment, or CIRA. In CIRA, you walk in, it's not an instructor-based class. So you walk in and your teachers will say, okay, today there's a missing 3-year-old in Miami-Dade County. This is the phone number for the child's father. He was last seen with them. Find the child. And again, it's a training environment, so you have to ask for the appropriate records in order to find that child and present your findings to your colleagues, to a team that's ready to go out and knock on doors and look for this child. If you do well in that, again, you go back, practice with those records, come back, and you can take the certification course. The certification course is 2 2-week sessions broken up into what we call Cert 1 and Cert 2. In Cert 1, you will actually get a chance to sit down with the providers and meet with the custodians of record and the engineers. The custodians of records are the folks that actually pull the records for you when we give them subpoenas and search warrants and exigent requests. And the engineers are obviously the folks who create, modify, and optimize the network so that we stay customers, because these are billion-dollar industries, right? And they want to keep doing that, keep making money, and keep us as customers. So that's a really great opportunity. The second part of Cert 2, in Cert 1, we also get about a semester's worth of training on radio frequency theory from professors from the Florida Institute of Technology. So it's the same professors that are teaching folks who actually go out and do this for a living, engineers in the field. In Cert 2, we have the opportunity to learn a new software that we use. It's called ESPA. And then we also learn a new piece of equipment. It's called the Gladiator Autonomous Receiver, or a GAR. If you remember those old commercials, I think they were Verizon, where the guy used to walk around and he used to go, "Can you hear me now? Can you hear me now?" Basically, what the receiver does is exactly that. It will drive every single block in a neighborhood and will act as though we're making a phone call, and will be a Verizon phone, a T-Mobile phone, a Sprint phone, an AT&T phone, and it'll say, "Can you hear me now? Can you hear me now? Can you hear me now?" And it'll actually figure out what the footprint of that tower is. So if I were to communicate with a tower, or if I was making a call, what tower would I connect to? In order to connect to a tower, one, very important, the phone has to decide which tower I'm going to connect to. And it does that based on what it views as the clear, strongest signal for itself at that time. After that, if you're anything like me, and you start your day as soon as you get in your car, you start making calls. I live in Broward County, so I'll start making my call at my house, and then I'll drive down to work, and sometimes I go down to Miami. So the ending...
I'll overrule the objection is a preface to the overall testimony. You could continue. You were driving in that scenario.
Thank you. So I'll start at my house, and then I'll continue driving until I get to work. If I'm headed to Miami that day, my ending tower will be in Miami. So both providers, in this case at least, provide both the beginning and ending towers for your records. And then you'll actually take a case in Cert 2 at the end of your training to a moot court. So it looks just like this. We go to a real courtroom and have defense attorneys and prosecutors that come in and help us. We take a case from initiation. We look at the records, we analyze those records, we create a report, we do a drive test to figure out the footprint, or what we call the ground truth of those records, and then we present our findings in a trial situation.
Okay. And how many of these analyses that you previously described have you actually conducted and performed during your career as a special agent for the FBI?
Well, not every case that I do goes to trial, so I'm looking at phone records on a weekly basis. So I've looked at over 100 phone records, well over 100. But trial is not typically that many.
Okay. And how many times have you testified in a court of law regarding these phone analyses that you previously described?
Regarding phone analysis, probably about 11 or 12 times.
Okay. And you're doing these analyses on a weekly basis?
Yes, most of the time, yes.
Over the course of how many years?
I became certified in 2021, but I started my first basic class. I was a tactical analyst beforehand, but you are not allowed to be certified in that position. But I took that class in 2016, so I've been working with these records since 2016.
Okay. And were you previously provided with phone records with respect to this case, the state of Florida versus Jose Soto-Escalera?
I was, yes.
Okay, and were you specifically provided with Sprint records where the subscriber, in which the subscriber was the defendant, Jose Soto-Escalera?
Yes, I was.
And were you also provided with T-Mobile records where the subscriber was a fellow by the name of Bradley Rodriguez, who paid for the phone for Tania Wise, the victim in the case?
Yes, I was.
Okay, I'm going to show you this particular item of evidence, which is a flash drive. What is on that flash drive?
These are the records that I received from both Sprint and T-Mobile for this case.
Okay, and did you, and when you say records, are these voluminous records?
They are, yes.
Okay, did you rely on those records to arrive at the conclusions in your case, in this case?
Absolutely, yes.
Thank you. Okay, and I am going to show you what has been marked as states 148 for identification purposes. Do you recognize that?
This is the report I generated for this case.
Okay, and what is, and you said it's a report. Go ahead and describe for the jury what data you looked at and how you analyze that data.
Sure. So phone carriers maintain a couple different kinds of records. The first is what's called the call detail record. If anybody remembers getting paper statements in the mail, you have a couple different columns. It's obviously one, your phone number, who you called, who called you, the date and time of that call, the duration of that call. It looks very similar to that. The only difference is with the call detail records is we have some tower information. So it'll actually tell us what tower you utilized to make that phone call, receive that phone call, send that text message, or receive that text message. Same with the data session. So we take those records and we marry them up with what's called the tower list. Phone companies are required to keep a tower list, and it's basically every tower within their network. But the call detail records, sometimes they'll refer to the towers as tower 1, 2, 3, 4. So we have to go to the call detail, to the tower list, I apologize, and see where tower 1, 2, 3, 4 is actually located. And that will give us the address and the lat and long of that tower. So we marry those two together to figure out, again, where these phone calls were taking place.
Okay, and the report in front of you, does that distill your analysis down to paper form? In other words, does it show the geographical area where these two phones were on the night of August 23rd of 2018?
It does, yes.
Okay, and is this a fair and accurate representation of your report?
It is.
And is it true and correct?
It is.
Okay, Your Honor, the state moves into evidence, exhibit number 148.
Any objection to 148?
May I just see it real quick?
The court's ruling 148 will come into evidence. And ladies and gentlemen of the jury, I did want to highlight something. If you recall, the beginning of the trial, and several times I've described to you the difference between demonstrative evidence and actual evidence. The significance of that is when something is actual evidence in the case, it will go back with you into the jury room. And when it's demonstrative, can be used here in court to explain other evidence. So just bear that in mind. There was a reference earlier to a thumb drive, which is just used demonstratively to explain the actual summary that's come into evidence at this time. In case you were wondering about the thumb drive, is not actually in evidence for later purposes. Thank you, and you may proceed.
Thank you. Okay, so why don't you, and we'll go ahead, is this the first page of your summary, is that correct?
It is.
Okay, and let's walk through and just make sure that we're specific here. There are two phone numbers, correct?
Correct.
The first is 772-607-0257. Okay, which individual is that phone number associated with?
That's associated with Tania Wise.
Okay, and then the second phone number, 772-200-61. Which individual is that associated with?
Mr. Escalera.
Okay, if we could advance to slide 2. So, and I think you described a lot of this already, but why don't you go ahead and just put a briefly summarize what we're looking at here.
Sure. So this just says what I did in my involvement in this case. I was given some records. I was given points of interest for this case and times of interest, as well as dates of interest. I mapped the records around those dates, times, and locations of interest using my software, and then I drew my own conclusions from those records.
Okay, and go ahead and advance to slide 3. So what are we looking at here?
This slide just shows examples of cell phone towers. Something I think that it's important to note here is just because you see a cell phone tower doesn't necessarily mean that your phone is communicating with that tower if you're close to it. So for example, I have Verizon for my personal phone. So my phone can only see Verizon towers. I may be standing underneath an AT&T tower. My phone doesn't even recognize that tower. So just because you're close to one doesn't necessarily mean that your phone is talking to that tower. And then something else just to note here is that carriers nowadays, depending upon the location, will try to have the cell phone towers blend in. They're not always these ugly structures on the side of the road like maybe we're used to seeing. So I think that cactus on the left-hand side there, I think that is in Arizona. I think Wyoming has one that's kind of built into like a billboard of a bison. So again, just because you see them doesn't necessarily mean you're just talking to them. And just because you don't see them, or potentially don't see them, doesn't necessarily mean they're not there.
Okay, and we'll go ahead and advance to the 4th slide. Okay, why don't you describe for the jury what we're looking at?
Sure. So most towers have 3 sides. Some towers have 6 sides, some have 1. Those are called omnidirectional towers. But for the purpose of this report, I think most of the towers in this report had 3 sides. When each tower is placed on Earth, it's not always pointed in the same direction. So we call that the azimuth or the orientation. And that's another column that we'll see in those call detail records. The carriers will let us know how the tower is oriented, so we know which direction this signal emanated from the tower to the phone. If you look at the photo all the way to the right, that's how I'll display cell sites that were that the phone interacted with. That shaded area does not show where the phone was located. That simply is just a guide for the direction the signal traveled. So it can or cannot be within that shaded area. And then a good way, I think, to think of my report, this is kind of a weird comparison, I know, but see how those lines are straight and it's very neat and kind of sharp looking? I like to compare that to almost like a cherry pie at Cheesecake Factory. It always comes really neat, the sides are straight, but if you ever cut a cherry pie at home, it's not neat. There's cherries that fall out, and even if you were to smack that cherry pie at home, typically it's still gonna be that wedge shape, and you can tell it's a pie, right? But you may have a couple crumbs that are not attached at all at that point. And that's actually a more realistic depiction of what the footprint of a cell tower actually looks like. Radio frequency is not a straight line, it's jagged. So just keep that in mind when we're looking at the report. The report has these sharp lines just to show a direction or again, as a guide. But radio frequency does not travel in a straight line like that.
Okay, and why don't you go ahead, I think this is a good point, to go ahead and describe to the jury some of the limitations of your analysis. You
Sure.
mentioned that the analogy of a cherry pie kind of won out. Why don't you go ahead and describe that for the jury, please?
Sure, so a couple things just to take into consideration. These records are maintained by the cell phone companies. I don't know who's holding the device at the time. If it's a phone call, I don't know what was said on that phone call. If it's a text message, I don't know what was written in that text message. If it's a photo, I don't know what the photo is of. Same thing with the data session. I can't tell that they logged onto Facebook or they sent an email. I can only say that the phone interacted with this tower at this time on this date. So just something to keep in mind throughout the report.
Okay, and if we could advance to slide 5 now, please. Thank you. Go ahead.
Time in advance is another record that the telephone companies keep. This is what we consider the golden standard. Time in advance is a record that will actually, it's a signal that's sent from the tower to the device and back to the tower. And based on the amount of time that it takes the signal to go from the tower to the phone and back to the tower, we can figure out with a mathematical equation based on radio frequency and how it travels at the speed of light, how far away that phone may be at the time that it made that phone call, or again, sent that text message. But, however, for time in advance, it's important to note that you don't have to be making a phone call to get a time in advance record. You don't have to be sending a text message. And you don't have to be within the footprint of that tower to talk to a tower. Time in advance is completely up to the network, and whatever tower wants to take a measurement of itself to the phone and back to itself can do so. So sometimes you'll get time in advance records that are very far away from the phone, and the phone is clearly not within the footprint of that tower. That's normal for time in advance. That's not typical for a call detail record.
Okay, and if we could advance to the next slide, please. Okay, what are we looking at here?
This is the phone number ending in 0257. So T-Mobile, anytime somebody signs up for their services, they keep a subscriber log. This phone is registered to Bradley Rodriguez, but again, used by Tania Wise. And it just says when they started their service, ended their service, and then a couple of other information about the actual device itself.
Okay, and if we could advance to the next slide, please.
This is the same thing, but for Sprint. This is for the number ending in 6163, subscribed to Mr. Escalera. And again, it just says when he started his relationship with Sprint, and then that the phone was maintained by him as a subscriber, his address, information like that.
Okay, and the next slide, please.
This is basically the same thing, just how Sprint kind of use it on their screen in their own program. But again, we can see that the phone ending in 6163 is subscribed to Mr. Soto-Escalera here as well.
Okay, is that this name right here, Jose Antonio Soto-Escalera?
Yes.
So focus in. Okay, and the next slide, please. Okay, and if it would be easier for you, if you would don't mind stepping down and kind of walking the jury through what we're looking at. here we are on the next slide. Go ahead and tell the jury what we're looking at.
So all of these green dots are T-Mobile towers. They make up the T-Mobile network. All of the black dots are Sprint towers, and they make up the Sprint network. I was given, as I said earlier, a couple different points of interest for this case. The first being this red flag here, that's the location of where the victim's body was found. The second here is this green flag, that's the victim's residence, or Mrs. Wise's residence. And this yellow flag is Mr. Escalera's residence.
Okay. And go ahead. I didn't mean to cut you.
You can see that the towers are kind of spread out here. This area is not super densely populated. If you were to go to an area like Manhattan or Los Angeles, you would see a lot more towers, a lot closer together, much more packed and condensed. But because this area, we have less people, less devices, less people that need resources from each of the towers, you have less towers. They're a little more spread out, and especially like in areas like this, I'll point out over here, you don't have a lot of towers. That's just because there's not a lot of people living there. It's very rural in this area.
Okay. In the next slide, please.
Okay, so here we have some timing in advance records and some call detail records, or phone calls that were made. I'll start with this one over here. See how this arc is a little bit darker than this one? That's only because there are actually quite a few timing in advance records that are almost pancaked on top of each other here. So the first one we'll look at was on August 23rd, 2018 at 8:06 p.m. And that's this outermost arc here. You can see that there's a little area that's just a little bit lighter, a little further west. That arc was 1.73 miles from the tower. This arc relates to the phone ending in 6163 used by Mr. Escalera. So that's telling us that the phone, used again by Mr. Escalera, was in an area consistent with the defendant's residence, with his own residence. And then if we look here at 8:07, 8:08, and 8:18 on that same day, August 23rd, Mr. Escalera's phone moves just a touch eastbound, and that's that darker shaded area here that we have three different, again, kind of pancaked on top of each other, timing advance records. Now if we continue on at 8:18 p.m., the phone again moved eastward closer towards the victim's residence. And we see that that arc was 0.94 miles away from the tower at that point. If we look here, these are all the phone calls that were made on this day from 8:06 p.m. through 8:18 p.m. on August 23rd. Let's look at the first one here. At 8:06 p.m., we can see that our target phone, the phone ending in 6163 used by Mr. Escalera, called a number ending in 0257. That was actually the phone that belonged to Tania Wise. That call lasted 38 seconds. It was a voice call, and again, it was from Mr. Escalera to Ms. Wise. Now, because we have Mrs. Wise's call detail records, we see that same call, but incoming to her phone right after. So it took about 2 seconds for it to register to get to her phone. And then again, the call lasted 32 seconds on her side, and it was an incoming call from Mr. Escalera's phone. Then Mr. Escalera at 8:07 and 8:08 p.m. calls two people. The first has a phone number ending in 3288, and the second a phone number ending in 8475. And then if we continue on again, just like the first two calls we saw that kind of were the same call really, we have that same instance here at 8:18 and 15 seconds. Mrs. Wise's phone calls Mr. Escalera's phone, and then we see the incoming call on Mr. Escalera's phone from Mrs. Wise, again at 8:18. And then we have another instance of that repeated call again at 8:18 and 15 seconds approximately later. Mrs. Wise's phone calls Mr. Escalera's phone, and then we see that incoming call to Mr. Escalera from Mrs. Wise's phone on his record. All of these calls were made from a tower right here, right where those two sectors kind of intersect.
Okay. And the tower, what can you say about the tower, the final tower that's that those calls communicated off of? Is that, how close to that is the victim's residence? Close to, how close is the tower to the victim's residence? I'm sorry.
So here's our key, but clearly less than a mile, maybe a block or two away from her residence there.
Okay, okay. And then, if we could advance to the next slide, please. So what are we looking at here?
So this is at 8:25 p.m. And then we have a couple different records that are just spread out by a couple different seconds here. So we'll start with the first one at 8:25 and 27 seconds. We have a call, an outgoing call from Mrs. Wise's phone to a number ending in 6163, which we now know is the phone used by Mr. Escalera. And that was done via this sector here pointed eastbound, the green sector. All of the green calls, if I didn't mention this earlier, belong to Ms. Wise, and all of the black calls in the black sectors belong to Mr. Escalera. At 8:25 and 28 seconds, we have again that same duplicative call, but on Mr. Escalera's record. So we can see that he received an incoming call from a number ending in 0257, which we know belongs to Ms. Wise, and he used this sector to receive that call. So towers may be in the same spot, and what companies will do sometimes is it costs a lot of money to build these towers. So once a tower is already built or constructed, they'll just put their antennas on top of each other. So sometimes you can see different layers, and sometimes it's different layers of the same network, sometimes it's different networks or different providers. But it looks like the towers are very close together, if not the same tower. The sectors are just different because remember how I said they orient their towers differently? So his tower, and specifically his sector that he used, is oriented just a little bit further north than Mrs. Wise's was here. Then at 8:25 and 50 seconds, we can see that there was a time in advance record for Mr. Escalera's phone that put him about 0.45 miles from the tower. Within 0.4 miles is Mrs. Wise's residence, which you can see here by that green flag.
Okay, so is it fair to say that Mr. Soto-Escalera's phone is within 0.4 miles away of the victim's residence on August 23rd, 2018 at 8:25 p.m.?
Correct. I would say this is an area that, or his phone is utilizing a tower that is consistent with being at or around her residence.
Okay. And if we could advance to the next slide, please. Okay, so what are we looking at here? It looks like we're looking at the time frame between 8:44 p.m. and 10 p.m. on August 23rd of 2018. Is that correct?
That's correct.
Okay. Go ahead and walk the jury through your analysis, please.
So we have a couple different things on this slide. I'll start with Mrs. Wise's phone down here to the south of the map. At 8:44 and 8:45, she made 2 calls, and she utilized a sector that was facing southbound, right here, kind of adjacent to the Florida Turnpike. Both of those calls were outgoing to numbers ending in 2218 and 7301. And here, typically on the other side, we saw a duration. Here it says -1. That's just a nuance with T-Mobile records. Sometimes they don't maintain the duration for certain calls, and when there's no duration populated in their call detail records, our software will kind of tell us that by just inputting a -1. So it's not that the call was -1 seconds, obviously that's impossible. There was just no duration noted there.
Let me stop you there if you don't mind.
Sure.
Is it accurate to say that at 8:25 p.m. until 8:44 p.m., the phone for Ms. Wise traveled north?
Yes. Yep, because if you remember at 8:25, the phone was further south down here by her residence.
Okay. And the same question for Mr. Soto-Escalera's phone?
Correct. So we don't see him over here, but we do see him even further north. And again, if you remember from the last slide, he was in that same general area of her house, just like Ms. Wise was.
Okay. So go ahead. Thank you. Go ahead and pick up on your analysis.
Sure. I'll switch over to this center call-out box right here. We're going to start with this call at 9:51. That was a outgoing call made from Mr. Escalera's phone to a number ending in 7131. And then this actually, if you remember earlier, I think I mentioned that the phone itself decides what tower it views as the best tower to make that call at the initiation of that call. And that's really important because the network takes over at the ending part of that call or anywhere after the initiation. So you can skip 10 towers, you can only have 2 towers in a call, you can have 1 tower. So the phone decides at the beginning of the call what tower it's going to connect to, and then the network takes over. So here you see how we have a 38-second call. Here's a 38-second call, and it's just 38 seconds after the first one. This is actually the ending tower for this same call. So that's why we don't have a phone number over here as well. So the call started over here from this tower and ended on this tower. Now, in between those two, we have a timing in advance arc. And cell phone coverage kind of works similar to a sprinkler system in your yard. You want to have a little bit of overlap just so you don't drop calls, because again, these people are in business to make money. If you're dropping calls, you're going to leave and you're going to go to another provider, right? They don't want that. So what they'll do is they'll create a little bit of overlap, but not too much that it overflows your lawn and your lawn is overflowed with water. In the radio frequency world, that creates what's called a lot of noise in the network. And it gets difficult for the phones to hear the towers to hear the phones, and vice versa. Based on how short this call was and where this time in advance point is, you can see that it's almost right in the middle of both of those towers, which tells me, knowing that there's no more towers in between here, that the phone was likely in this area when it made that phone call. After it made that phone call at 9:52, we'll go to this one at 10 p.m. here. Mr. Escalera's phone made a call to a number ending in 8475, south of that initial call from the slide, but again, using a sector that was pointed northbound, and that's this one right here. And we can see that the timing advance arc for that tower was about 1.3 miles away from the tower. I think that covers this slide.
Okay. And let me ask you this. What is the closest point that the defendant's phone, Jose Soto-Escalera, got within the intersection of Johnston Road and Russo Road, which is our crime scene?
So this right here, this red flag is again the crime scene where the victim's body was found. This to the tower is 4.33 miles. I would say that that is probably less than 2 miles away.
Okay. And does that include the outside of the crime scene as well?
Yes, it does.
Okay. Okay. And if we could go, I believe that's the last slide. If we go to, okay, that is the last slide. Okay. Thank you. You can. Thank you. Okay. Agent D.P. Trantonio, thank you very much. I have no further questions. Defense counsel may have some for you.
Thank you.
No cross touch, thank you.
May this witness be released from her subpoena at this time?
She may.
Any objection to releasing her?
No objection.
Thank you, Agent D.P. Trantonio. You are releasing your subpoena. You're free to stay or leave as you wish.
Thank you.
Thank you. And the state's next witness or item of evidence.
Donna Carmichael with the St. Lucie County Sheriff's Office.
Do you swear or affirm that the evidence you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
And you may inquire of the witness.
Morning.
Good morning.
Please state your full name and spell your last name for the record.
Donna Carmichael, Carmichael.
All right, and are you currently employed?
No, sir, I'm not.
Okay, you're recently retired?
Yes, sir.
All right, what did you retire from doing?
I retired from the St. Lucie County Sheriff's Office. I was the crime scene supervisor there.
All right, and if you could tell the jury, how long did you work for the St. Lucie County Sheriff's Office as the crime scene supervisor?
I worked for the Sheriff's Office for 31 years. The first 11 years, I was the evidence custodian
For 12 years, I was a crime scene investigator. In the last 8 years, I was the supervisor of the unit.
All right, and if you could tell the jury what was your background and your training and experience that allowed you to be able to do that job and work all the way up to the supervisor for the St. Lucie County Sheriff's Office?
I have thousands of hours of training through different organizations such as the FBI, the American Institute of Applied Science, West Virginia University, North Carolina Justice Institution, the International Association of Identification, and LEVA, which is Law Enforcement Video Analysis, and other forensic discipline organizations. Through that, the training is through documenting scenes, processing evidence, video analysis, latent print analysis and comparison, homicide scenes, death investigations, shooting investigations, to just name a few of the different types of training that I attended.
All right, and as far as the crime scene supervisor, were you employed in that capacity back in August of 2018?
Yes, sir.
And were two of the other crime scene investigators, Kayla Lim and Janine Hiller, did you supervise them at that time?
Yes, sir.
And did you provide assistance to them in working the homicide case of Tania Wise?
Yes, sir.
What was your involvement in the case as far as the collecting and the documentation of physical evidence?
Well, there was several different days. We worked on this case for multiple days and weeks. On the initial scene, I assisted CSI Hiller with the documentation of measurements, because of course you need two people to hold a tape measure and that. And then when it came time to examine the victim, I assisted with the examination by allowing her to be able to take photographs while I adjusted the victim, moved the victim for her so that she could take photographs.
All right, so now let's go to August 25th, 2018. Did you assist in the collection of evidence from the defendant's truck?
Yes, I did.
Okay. And what I'd first like to just show you is some photographs that have been marked. And those have been marked as State's Exhibits 171 through 182. If you could just tell me if you recognize these photographs.
Yes, sir.
All right. How is it that you recognize those photographs?
These are the photographs that I took that day
And where did you take those photographs?
at the St. Lucie County Sheriff's Office in the Criminal Investigations parking lot.
And what are the photographs of?
They are photographs of the defendant's truck, a silver Dodge Ram truck.
All right. Do those photographs accurately reflect the defendant's vehicle as it was at the St. Lucie County Sheriff's Office on August 25th of 2018?
Yes, sir.
At this time, the state would move into evidence which was marked for identification, states 171 through 182. They did. Just the same.
Any objection?
No objection, Judge.
Those items will come into evidence at this time without objection.
Publish these photographs. All right, so we have State's Exhibit 171 up on the screen. Where is this parking lot located?
It is on the west side of the sheriff's office in the fenced-in area, which is normally employee parking for the detectives.
All right, and then we're looking at, this is a side photograph, passenger side of the defendant's truck.
Yes, sir.
All right, State's Exhibit 172. I think we can see you in the reflection of the tailgate. What is it? What are we looking at here?
The rear tailgate area in the back of the pickup truck showing the license plate number.
States 173.
That is the driver's side of the vehicle.
Okay, why do you take all these different photographs?
We do it to show if there's any damage or any other evidence that might be easily seen with, through taking photographs, and to show the condition of the vehicle when we first see it.
174.
That is the front area of the vehicle to show the front quarter panel and driver's area of the vehicle.
175.
And again, the actual front of the vehicle to show what it looks like.
176.
That is the bed of the vehicle,
177.
just a different angle, making sure we can get all of the areas of the bed.
Let's see, 178.
This is the interior section of the driver's side of the vehicle.
179.
This is a close-up so that it captures the center console area and the seat, and to show that the items on the seat.
180.
This is the back driver's side seat showing that area.
181.
A pair of shoes that were on the floor of the vehicle,
And 182.
the bottoms of the shoes.
Now, in addition to photographing the defendant's vehicle on that day, did you and Ms. Lim also do swabs of the vehicle?
Yes, we did.
Okay, and did you work on the driver's side of the vehicle while Ms. Lim worked on the passenger side?
Yes, sir.
Okay, at this time, I'd like to show you what's been previously marked as state's exhibits 152, 153, 154, and 160.
Okay.
Do you recognize these items?
Yes, sir.
All right, then as far as 152, 153, and 154, what are these?
There's DNA swabbings that I did of the interior of the truck.
Okay, and if you could describe for the jury just briefly, how do you do that?
What we do is we take sterile swabs that are packed, two swabs come in a package together. They're sterile, and we open that package. We have small vials of sterile water that we will moisten one of the swabs with the sterile water and leave the other swab dry. We keep the two swabs together when we're swabbing an area so that they're together. Then we will rotate the swabs while we are swabbing the area, and then put the swabs back in the sterile package, and then they go into an evidence envelope.
All right, as far as state's exhibits 152, 153, 154, are those swabs that were taken from the vehicle?
Yes, sir.
And then state's exhibit 160, how do you recognize that exhibit?
It has my handwriting and information on the package.
And what is that exhibit?
It's hairs that was found on the right shoe.
The shoes from those pictures?
Yes, sir.
At this time, the state would move into evidence with the mark for identification 152, 153, 154, and 160.
No objection.
Those items will come into evidence without objection.
So as far as that day with that truck, is that your, the extent of your involvement with that vehicle?
Yes, sir.
All right. So in addition to taking those swabs, did you also take some buccal swabs in this case?
Yes, sir.
Okay, and what is that?
A buccal swab is basically a DNA swab to collect a person's DNA. And what we do is we have special swabs that come in special tubes that we can swab the interior of a person's mouth. And we take two different swabs and swab each side of the mouth, one swab on one side and one swab on the other. And then those are submitted to evidence.
All right, So in this case, did you take a swab of the defendant, in this case, Jose Soto-Escalera?
Yes, sir.
Okay, I would like to show you what's been marked for identification in State's Exhibit 161. You recognize that?
Yes, sir.
How do you recognize it?
My handwriting is on the package.
All right. And is there any identifying information that shows it was you that did this swab?
Yes, sir. It has my initials and my ID number,
What was your ID number back then?
1030,
Okay, and what is the date that you took this swab?
8/25 of 2018.
Okay, do you see the person that you took the swab from, Jose Soto-Escalera, here in the courtroom today?
Yes, sir.
If you could you point to that person, identify him by an article of clothing?
He is sitting over to my left. He is wearing a black jacket and a blue-colored shirt.
Okay, so that's the person that you swabbed, and that's the swab that's inside of this envelope, State's Exhibit 161?
Yes, sir.
All right, this time, State will move into evidence that's marked for identification in State's Exhibit 161.
No objection.
That item will come into evidence without objection.
Did you take some other buccal swabs of some other people in this case?
Yes, sir.
And would those be Giovanni Alvarado, Mark Burke, and Bradley Rodriguez?
Yes, sir.
All right, this time I'd like to show you what's been marked for identification, State's Exhibits 162, 163, and 164. 164. Do you recognize those?
Yes, sir.
All right, how do you recognize those?
Again, it has my handwriting and the information on the packages.
All right, and then do you document who you're swabbing on each one? You write the name of the person that you're swabbing,
Yes, sir.
and you place those in those envelopes?
Yes, sir.
How are these, I guess, what is, just so the jury knows, what is all the writing that's on and the tape? What is all of that?
That is our initials, our ID numbers, and dates of when we sealed the package. So then, like on this one, it has my initials and date up here, but somebody else opened the package at a later date, and they signed down at the bottom of the package and dated on this side of the package. We always try to open the package in a different location than where it was sealed, but unfortunately, sometimes a package gets opened multiple times for different reasons, and but everybody tries to not sign over top of somebody else's seal, so it's resealed each time.
What are reasons why packages have to be reopened and then resealed?
It all depends on the evidence and who collects it. If say a road deputy collects a piece of evidence, or a detective collects a piece of evidence, and the crime scene unit needs to examine that for trace evidence or process it for fingerprints or something like that, then it will come into the crime scene unit, and we would have to open that package to then process it, and once we're done, we would repackage it and seal it. Also, it could, if it is a cell phone or something like that, it could go to our forensics lab, where the detective that handles cell phones and pulls data from those, they would have to unseal it and then reseal it again. And a lot of things go to lab to be analyzed by an analyst at the lab, so they would then unseal it and reseal it.
So if there's a buccal swab and you guys put it in an envelope and seal it, if you send it to the lab, does it have to be reopened to be tested?
Yes, sir.
Okay, but every time that it's opened, it's documented and it's initialed and it's dated.
Yes, sir.
At this time, the state will move into evidence which is marked for identification. State's Exhibits 162, 163, and 164.
Any objection?
No objection.
Those items will come into evidence without objection.
Thank you, Ms. Carmichael. That's all the questions I have for now.
Yes, ma'am. When you took photos of my client on August 24th, 2018, you did not see any visual injuries or abrasions, correct?
Correct.
And at that time, my client gave verbal and written consent to give his DNA, right?
Yes, ma'am.
And swab his truck.
Yes, ma'am.
And you also, I think the state mentioned, got the DNA from Mark Burke, Giovanni Alvarado, and Bradley Rodriguez, correct?
Yes, ma'am.
Bradley Rodriguez Jr., I should say. I have no further questions at this time.
Any further questions from the state?
No, Your Honor.
May Ms. Carmichael be released from her subpoena at this
She
time?
is subject to recall.
If you please step down, and you do remain subject to recall by the attorney so long as they, or make sure they have a phone contact for you. Thank you. And the state's unique approach?
Just a break.
Okay. Ladies and gentlemen, let's take a restroom break. I know I've sent you back many times, but the attorneys need a break as well. Please remember during the break, leave your notes on your chairs. Don't discuss the case with each other. We'll be with you in about 10 minutes. Jury has exited and will be in recess for about 10 minutes. Give you all a restroom break. All right, the jury is present. We continue with the state's case. The state may call its next witness.
Call Wayne Walker with the Indian River Crime Laboratory.
So if you can go forward, raise your right hand, face the clerk.
Do you swear affirm that evidence you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Good morning. Good morning.
If you could, please state your full name and spell your last name for the record.
My full name is Wayne Austin Walker Jr. My first name is spelled W-A-Y-N-E, and my last name is W-A-L-K-E-R.
All right, and how is it that you're employed?
I'm a criminalist in the biology section at the Indian River Crime Lab.
And how long have you been working with the Indian River Crime Laboratory?
Since October of 2014.
All right, what is your specific job title?
I'm a criminalist in the biology section.
Criminalist. So what does a criminalist do?
So I examine items of evidence for biological materials such as blood, semen, and saliva. I then try to develop a DNA profile from unknown evidence samples. And if I am able to develop a DNA profile from that unknown evidence, I'll do a comparison to any known standards that I have, and I'll perform statistical analysis to determine how common or rare that unknown profile is. And then I write a report and testify when needed.
All right, now, prior to being able to do this type of analysis, I assume you have to have some training and a certain education?
Yes, I do.
If you could tell the jury about your background as far as your education and then your training leading up to you doing this job.
From the University of Central Florida, I have a Bachelor's of Science degree in forensic biochemistry, along with minors in chemistry and micromolecular biology. And from the University of South Florida, I have a Master's of Science degree in medical science with a concentration in health science. I started my career at the Florida Department of Law Enforcement at the Orlando Regional Operations Center. I started as a forensic technologist in the biology section. Basically, it's an entry-level science position. I helped clean the lab, make chemicals, do some maintenance on some instruments. After about a year and a half, I was promoted to a crime laboratory analyst in the biology section, at which point I went through about a year and a half training program. It's divided into 2 phases. The first phase deals with readings and working on practice samples, and the readings are about the techniques used in DNA analysis as well as statistical methods used in DNA analysis. I then work practice samples. At the completion of the first phase, the second phase is supervised casework. So I started working actual cases under the direction of an already trained analyst. I was an analyst, caseworking analyst at FDLE for about 4 years before coming to the Indian River Crime Lab, at which point it was about a 6-month training program. I kind of say, I used to work at McDonald's, now I work at Burger King. One makes Whoppers, the other makes Big Macs, but it's really just burgers and fries. So both labs are doing the same thing. Some things are a little different, and that's what the 6 month of training was about at Indian River Crime Lab.
All right, now as far as the Indian River Crime Lab, is that certified?
It's an accredited laboratory, yes.
All right, and do you have to continue to have training periodically to able to keep doing what you do for your living?
Yes, I am required to have at least 8 hours of continuing education each year.
All right, and have you ever testified previously in court?
Yes, I have.
Approximately how many times?
Roughly 60 times.
All right. Now, can you, I guess, explain the difference to the jury between what is called, you referred to an unknown standard or an unknown sample versus a known standard?
So when you have DNA, there's no name. It's really what it looks like is peaks on a graph. So when you get evidence from an unknown source, you just have these peaks on a graph. It doesn't tell you whose this is. So what we'll do is, after we determine what we can interpret, I'll then compare it to a known standard, which usually comes in the form of an oral swab or a blood stain card or a blood swab from an individual. And that way I know what is this person's profile, what are the peaks that I would see, and I can use that to compare to the unknown profile from the evidence.
All right, and can you just explain the physical process of how you do a DNA? I guess, how does a typical case where you get some swabs or a sample in the lab, how does that work? What do you do?
So for the very first thing that I'll do when I get evidence is I make sure that the packaging is properly labeled and is sealed. The packaging is sealed, it's properly labeled. I'll do whatever testing may be required, what's called the serology or body fluid identification. And then I'll take samples on for DNA analysis. And the DNA analysis, the first step is called extraction. And this is basically adding some chemicals and heat and just trying to break open the cells to get to the DNA. The second step is called quantitation. So I actually want to know how much DNA is present in my sample, because how much DNA I have can affect my later processes. So I kind of think, I like to use a lot of analogies. And this is sort of like orange juice concentrate. You don't just drink straight orange juice concentrate, you have to dilute it out. And the same thing happens with DNA. If I have too much DNA, that can affect my later processes. So I may have to make a dilution of that sample. On the flip side, if I have not a lot of DNA, if I don't get very good results, well, I know why I didn't get good results. There wasn't a lot of DNA to be processed. So it's also a good quality control measure. The next step is called amplification. And I actually don't look at all of an individual's DNA. We only look at 21 specific areas, and we make billions of copies of those 21 specific areas. This DNA is then, these copies of the DNA are then put on an instrument that separates it based off size. And this is represented graphically. These are the peaks on the graph I mentioned earlier. So it's these peaks on a graph that I will use to interpret.
All right, now as far as you use this term DNA, what is DNA?
DNA stands for deoxyribonucleic acid. It's the genetic blueprint that makes up all life. Humans actually have 2 copies of DNA. You get 1 copy from your mother, you get 1 copy from your father. This is determined at conception, and it remains the same your entire life, and all the cells of your body have the same DNA. So whether it's your blood or your skin cells or the inside of your mouth, all of those cells have the same DNA profile, and no two individuals have the same DNA profile except for identical twins.
All right, so my DNA is my DNA alone. Nobody else has the same DNA. I don't have an identical twin, so no one else has the same DNA that I would have.
That's correct.
All right. So I want to talk about some of the evidence that you received in this case. Is one of the things that you could do at the crime laboratory is determine paternity or who the father is of a child?
Yes, we do paternity testing for criminal cases.
Okay, and were you asked to do some paternity testing in this particular case?
Yes, I was.
All right, so what I want to do is, before I show you any exhibits, how do you determine paternity? What do you need from the sheriff's office or from law enforcement to be able to do that analysis? What is required?
So first there'll be from the child, because I need their DNA profile, the mother, and again, so remember when I talked about DNA, humans have two copies, one comes from the mother. So from that child, if I know what the mother's DNA profile is, I can subtract out her DNA, and what I'm left over is what's obligate DNA from the father. The father has to have these peaks. So then I need standards from individuals who are the alleged father to do a comparison. And then if I cannot exclude that alleged father, I'll perform statistical analysis to give some weight to that person's inclusion as a possible alleged father.
All right, so in this particular case then, and these have already been entered into evidence, States Exhibits 9 and 144. States Exhibit 9 is the blood standard of Josiah Wise. And then States Exhibit 144 would be the blood standard of Tania Wise. Can you take a look at those and let me know if you recognize those exhibits?
Yes, I do.
How is it that you recognize them?
So on both of the exhibits, there is a barcode sticker from the Indian River Crime Lab that has the Indian River Crime Lab case number and exhibit number. And then it's covered up with a sticker here, but you can see it more clearly here. I hand wrote the Indian River Crime Lab case number, the exhibit number, the date I examined it, and my initials.
All right. So were you able to get a DNA profile for each of those two standards?
Yes, I was.
All right, so those would be the mother and the child. What is missing for you to then determine whether or not someone's the father?
Standard from an alleged father.
All right, and did you receive additional standards in this case from some males?
Yes, I did.
And what I'd like to do is provide you with States Exhibit 8, which is the DNA standard of Eric Alvarez. States Exhibit 162, the DNA standard of Mark Burke. States Exhibit 163, the DNA standard of Giovanni Alvarado. And then States Exhibit 164, the DNA standard of Bradley Rodriguez. Mr. Walker, do you recognize those exhibits?
Yes, I do.
How do you recognize them?
So again, each of them I'll put up two at a time. They have the Indian River Crime Lab barcode sticker with the Indian River Crime Lab case number and exhibit number. And then I hand wrote, and I'll put the other two, I hand wrote the Indian River Crime Lab case number, exhibit numbers, the date I examined these, and my initials.
All right, and were you able to get a standard DNA profile for each of those individuals we just listed?
Yes, I was.
All right, and then did you do a comparison to the previously referenced standard of Josiah Wise, the baby, and the victim, Tania Wise, to see if any of those individuals could be the father of Josiah Wise?
Yes, I did.
Okay, and what were the results of that analysis?
So the DNA profiles from the child, baby Wise, and the mother, Tania Wise, were compared with that with these alleged fathers, and these individuals are not consistent with having the DNA profile of that required to be a child's biological father.
Okay, can you confidently say that?
Yes.
Okay, how can you say that?
The obligate markers that are needed, these individuals, maybe there might be some sharing, but they don't have, there are places where they are missing an obligate that needs to be present. So they would be excluded as the alleged father.
All right, now I'd like to show you what's been marked for evidence. States Exhibit 161, This is the DNA swab of Jose Soto-Escalera. Do you recognize that?
Yes, I do.
How do you recognize that?
It has the Indian River Crime Lab barcode with the case number and exhibit number. And then I hand wrote, again, it's covered, but I hand wrote the Indian River Crime Lab case number, exhibit number, the date I examined it, and my initials would be under that sticker.
All right. And were you able to get a complete male DNA profile from that standard?
Yes, I was.
All right. And did you compare that standard to those previously analyzed of Baby Wise and Tania Wise?
Yes, I did.
Were you able to reach a conclusion as to whether or not the defendant in this case, Jose Soto-Escalera, is the biological father of Josiah Wise?
Yes, I was.
Okay, and what was your conclusion?
So the DNA profiles from the child, Baby Wise, and the mother, Tania Wise, were compared with that of the alleged father, Jose Soto-Escalera. The DNA profile from Jose Soto-Escalera is consistent with that required of the child's biological father. And now I'm going to read two stats that give statistical weight to that statement. The first is what's called the parentage index, and this is an odds ratio that determines how much more likely the alleged parent is to be the biological parent than an unknown random individual, and the parentage index is approximately 241 trillion. The next stat is called the probability of parentage. This is the chance that the alleged parent is the biological parent when compared to a random individual, and this is approximately 99.9999999999.
Is that 10 nines?
Yes, it is.
So
99.109.
Percent.
Yeah, percent.
That he's the father of the child?
Yes.
In addition to those standards, did you also receive swabs from evidence in this case?
Yes, I did.
All right.
What is StarMix?
StarMix?
Yeah.
So StarMix is a software program. It's called probabilistic genotyping software program. And StarMix, it's a tool that's used to help interpret data for DNA analysts. It uses biological modeling, probability theory, statistical theory, and computer algorithms to help infer the DNA profiles that would explain the unknown profile that I have.
Now I want to ask you about some items of evidence that you've received in this particular case. The first one I want to show you is State's Exhibit 7. Do you recognize this?
Yes, I do.
Okay. How do you recognize that?
It has the Indian River Crime Lab barcode sticker with the case number and exhibit number, and then I hand wrote the Crime Lab case number, exhibit number, the date I examined this, in my initials.
All right. For the record, you're looking at State's Exhibit 7, which is a DNA swab from a flashlight. Were you able to, I guess, what do you do when you get that swab in the lab, and what happened after you did your examination? And I believe for you, the number 295781.
So what I did with this exhibit is I tested it for DNA. I took a cutting, put that in a tube, and then performed the DNA analysis method on it.
And did you find any DNA on that item?
Yes, I did.
All right, and did you compare it then to the profiles? Well, I guess, did you find a major contributor or a minor contributor?
So my results of what I got was a DNA profile obtained from the swabs of the flashlight was consistent with being a mixture of a major and a minor component. A male DNA profile was obtained from the major component of this mixture at 15 locations. Results at the remaining 6 locations were inconclusive due to insufficient DNA quality and/or quantity.
So did you compare the major contributor, the DNA profile that you found, to the males that we previously referenced?
Yes, I did.
Okay, and did it match any of them?
They were all excluded as a contributor to the major profile.
All right, so there you found, to summarize State's Exhibit 7, found some male DNA is on it, it's present, but it doesn't match Mark Burke, Giovanni Alvarado, Eric Alvarado, Bradley Rodriguez, or the defendant.
That's correct.
All right. State's Exhibit 160, hair from Nike shoe. Do you recognize that item?
Yes, I do.
How do you recognize that one?
It has the Indian River Crime Lab barcode sticker with the case number and exhibit number. I hand wrote the Crime Lab case number, the exhibit number, the date I examined it, and my initials.
All right, and based on your examination of that item, what came of it?
So for hair, I do an examination of the root end of a hair. Hair probably is the thing that is most, there's a lot of misinformation from TV and things like that. A lot of hair falls out naturally, and you can't get nuclear DNA, the type of DNA testing I do, from the hair. The hairs that we need to get DNA from have to actually be pulled from the head, so there's some skin material. So I looked at the root end of the hair that was on this, and it was found to be eligible for nuclear DNA analysis. But when I did my testing, it was subjected to DNA extraction procedures, but it failed to yield sufficient STR DNA. So basically what that means is this hair, when I looked under a microscope, it was good enough to at least try, but when I did the DNA process, there's no DNA on this sample.
So you can't do anything with it, because there was no DNA.
There's no nuclear DNA.
All right. And then I want to ask you the same questions for some additional items. These are all involved. It's State's Exhibit 22, hair from left hand. State's 23, hair left thigh. State's 24, hair left waist. State's Exhibit 25, hair left side. State's Exhibit 26, hair from inside back of blue underwear. And then 27, hair from back of gray and blue underwear. Do you recognize those items?
Yes, I do.
And how do you recognize it?
So it's under this green card, but each of them has the Crime Lab barcode sticker with the case number and exhibit number, and then I can see my handwritten, I hand wrote the case number, exhibit number, the date I examined it, and my initials.
In the analysis that you just described in reference to hair, did you also perform that same analysis for each of those exhibits?
Yes, I did. I examined them microscopically.
And what were your conclusions? Were you able to get any nuclear, DNA for examination?
So I didn't even try. These were, after looking at a microscope, they were unsuitable for nuclear DNA analysis.
Okay, and what do you see that makes it unsuitable?
The hair, when it's unsuitable, it'll kind of have like a baseball bat shape. And that is because the hair is actually coming out of the follicle. So it detaches itself from the follicle. So it starts to shorten and becomes bulbous. And there's no, what I can see under a microscope of looking like skin, we call it a follicular tag. So no skin or anything like that on there. So if it's just this, kind of looks like a bulb, baseball bat, some people call it like a light bulb, then it's not even, I'm not going to attempt nuclear DNA analysis. I probably won't get anything.
All right. Now I want to ask you about some items that have already been entered in evidence. These are swabs from the victim. We have State's Exhibit 11, DNA swabbing from left-hand fingernail. State's 12, DNA swabbing from right-hand fingernail. 13, fingernail scraping left ring. 14, fingernail scraping right thumb. State's 15, fingernail scraping right middle. 16, DNA swabbing from left breast. And 17, DNA swabbing from right breast. Same questions as before. Do you recognize them? How do you recognize them?
So I do recognize them. Again, probably the best. They each have the Indian River Crime Lab barcode sticker with the case number, exhibit number, and then I've handwritten the case number, exhibit number, the date I examined it, and my initials.
All right, and for all of the victim swabs, did you perform an examination?
Yes, I did.
Did you find any DNA that was foreign to the victim on those items?
So I did additional testing on some of the items first, which is I tested them a presumptive test for blood. So the swabs from the left-hand fingernails, the swabs from the right-hand fingernails, and the swabs from the right breast, they tested positive chemically, indicating the presence of blood. I then did DNA analysis, and for all of these exhibits, the results were there were no DNA results foreign to Tania Wise were found on these following exhibits.
All right, but some of them did have blood present.
They did not.
They did not have blood present.
Or they did not have a red-brown staining that would give me an idea to look for blood, to do my testing for blood.
All right, now I want to ask you about State's Exhibit 18 that's been entered. It's the vaginal swabs from the sexual assault kit that's already been entered into evidence. Do you recognize that item?
Yes, I do.
How do you recognize it?
So this item came from a larger package that would have the Indian River Crime Lab barcode sticker. So this was inside, but I still handwrite the exhibit number, the case number, the date I examined it, and my initials, and those are present on here.
All right, and what analysis, do you do anything different or a different chemical test for this because it's a vaginal swab from a sexual assault kit?
Yes, so for the vaginal swabs, they tested negative chemically and microscopically for the presence of seminal fluid.
All right, so once you know that result, do you go any further with that?
Yes, so just because there's not semen, there could have been perhaps oral assault or digital penetration, so there could be DNA foreign to the victim on this sample anyway. Every time someone has sex, it doesn't mean they ejaculate it. So I did DNA analysis on this sample, and the vaginal swabs were subjected to DNA extraction procedures, but they failed to yield sufficient male DNA for STR analysis. No further analysis was performed on this exhibit.
All right, so based on the results that you got at the crime lab, you couldn't do any further analysis?
That's correct.
I'd like to show you what's been marked for or it's already been entered into evidence, State's Exhibit 33. This is the swabbing of the rear passenger door pull of the Dodge Ram truck. Do you recognize that?
Yes, I do.
How do you recognize it?
So it has the Indian River Crime Lab barcode sticker with the exhibit number and case number. And then I hand wrote the crime lab's case number, exhibit number, the date I examined it, and my initials.
All right, did you perform the same DNA analysis on that item?
Yes, I did.
And what were the results of your examination?
Oh, okay. So from this item, I obtained a mixture of DNA profiles from 2 individuals was obtained from the swabs from the rear passenger door pull. And then I did do a comparison to the standards that I have.
All right, and would those have been Eric Alvarado, Jose Soto-Escalera, Mark Burke, Giovanni Alvarado, Tania Wise, and Josiah Wise?
Yes.
And I think Miss Bradley Rodriguez. What were your results?
So Eric Alvarado, he cannot be excluded as a possible contributor to this mixture. For the locations I was able to perform statistics at, the probability that a randomly chosen unrelated individual would be included as a possible contributor to this mixture is approximately 1 in 137 billion. Bradley Rodriguez, Jose Soto-Escalera, Mark Burke, Giovanni Alvarado, Tania Wise, and Baby Wise are excluded as possible contributors to this mixture.
So in the rear passenger swab, Eric Alvarado cannot be excluded, but the rest of the people that you have standards for can.
That's correct.
Next, I'd like to show you what's been entered into evidence as State's Exhibit 152, the swabbing from the front passenger headrest.
You recognize that one?
Yes, I do. So it has the crime lab barcode sticker with the case number and exhibit number, and then I hand wrote the case number, the exhibit number, the date I examined it, and my initials.
All right. And did you perform an analysis on this exhibit, State's Exhibit 152?
Yes, I did.
Okay, and what were the results?
Mixtures of DNA profiles from at least 3 individuals was obtained on the swabs from the front passenger headrest. Due to the complexity of this mixture, no further conclusions are possible regarding this profile.
All right. Is there ever a time where evidence that's been examined by your crime laboratory is then also sent to another lab?
It does happen occasionally, yes.
Okay, did that happen in this case?
Yes, it did.
How does that happen?
So it depends. There's different ways. For this situation, the sheriff's office wanted to have additional testing done that is not performed at the Indian River Crime Lab. So when I do my testing, that first step is called extraction. That's getting the DNA out of the cell. What's left over is like a small amount of liquid. I don't use all of that liquid. I use a portion of it, and then we retain or save that in case there's ever further testing that's needed. So this extract was given to the sheriff's office, and if they pursued further testing, they would be able to with that extract.
All right, so for some of the exhibits in this case, there were extracts that were made, or is that something you do on every single piece of evidence?
Every piece of evidence starts with the DNA process. There is an extract left over because it's extracted, so then there's an extract.
All right, so for every swab, there were extracts, but the extracts themselves can be sent to other labs if additional testing is requested by the agency.
Yes, it can.
Okay, and are you aware whether or not that was done in this case?
The only part I know is that the extract was given to the sheriff's office. I don't know what happened with it afterwards.
What I'd like to show you next is State's Exhibit 153, swabbing from the steering wheel. Do you recognize that exhibit?
Yes, I do.
Okay, is this another item that went to your lab in reference to this case?
Yes, it did, and I can recognize it. It has the crime lab barcode sticker with the case number and exhibit number, and then I hand wrote the case number, the exhibit number, the date I examined it, and my initials.
All right, and what were your results in reference to State's Exhibit 153, the steering wheel?
The DNA profile obtained from the swabs of the Dodge truck steering wheel was consistent with being a mixture of a major and a minor component. The male DNA profile obtained from the major component of the mixture matches the DNA profile obtained from the oral standard from Jose Soto-Escalera at 15 locations. Comparisons at the remaining 6 locations were inconclusive due to insufficient DNA quantity and/or quality. For those 15 areas, the frequency with which the major evidence DNA profile is expected to be found in an unrelated individual in the population at large is 1 in 288 quintillion, and then no comparisons are possible to the minor component of the mixture profile due to insufficient DNA quantity and/or quality.
All right, so the major contributor in this case is Jose Soto-Escalera.
His profile matches, and then this is a stat to give weight. So
Okay,
he
and
matches.
it's the number that you gave?
Yes, so what that number is what is the chance that you were to randomly select a person, an unrelated person from the population at large, and they would also happen to match. For this major profile, it's 1 in 288 quintillion.
How many zeros is quintillion?
Quintillion has 18 zeros, so it's 1 followed by 18 zeros. To get to a quintillion is a billion times a billion.
So that's a high number.
A quintillion is a large number, yes.
Now I want to show you State's Exhibit 154. You recognize this one?
Yes, I do. It has the crime lab barcode sticker with the case number and exhibit number, and then I hand wrote the crime lab case number, exhibit number, the date I examined it, and my initials.
All right, and what were the results of your analysis on this this item 154?
So this the DNA profile obtained from the swabs of the Dodge truck driver's door was consistent with being a mixture of a major and a minor component. The male DNA profile obtained from the major component of this mixture matches the DNA profile obtained from the oral standard from Jose Soto-Escalera at 12 locations. Comparisons at the remaining 9 locations were inconclusive due to insufficient DNA quantity and/or quality. For those 12 locations, the frequency at which the major evidence DNA profile is expected to be found in an unrelated individual in the population at large is approximately 1 in 40 quadrillion. No comparisons are possible to the minor component of this mixture profile due to insufficient DNA quantity and/or quality.
Now I want to show you what's been entered into evidence. Swabbings from top of armrest, State's Exhibit 155. You recognize that one?
Yes, I do. It
Okay.
has the Indian River Crime Lab barcode sticker with the case number and exhibit number, and then I hand wrote the case number, the exhibit number, the date I examined it, and my initials.
All right. What was the results of your analysis on State's 155?
This was an inclusive mixture of DNA profiles was obtained from the swabs of the driver armrest top and is not suitable for comparison to any known standards.
All right. So you, based on what you saw, there's nothing you can do with that. No further testing you can do.
Yes, so this is an inconclusive mixture. There's so a mixture is being DNA from more than one person, but I can't interpret and tease out the different contributors. So I can't interpret this data.
I want to show you now, entered as State's 156, swabbing from the bottom of the armrest. Do you recognize it?
Yes, I do. It has the Indian River Crime Lab barcode sticker with the case number and exhibit number. And then I hand wrote the case number, the exhibit number, the date I examined it, and my initials.
And what were the results of the examination on that one?
This also was an inconclusive mixture of DNA profiles was obtained from the swabs of the driver armrest bottom that are not suitable for comparison to any known standards.
All right. And now we'll show you what's been entered as State's Exhibit 28, DNA swabs, driver door behind handle. Same question. Do you recognize it? How do you recognize it?
I recognize it. It has the Indian River Crime Lab barcode sticker with the case number and exhibit number. And then, again, I can't see, but I hand wrote the case number, the exhibit number, the date I examined it, and my initials are on this package.
All right, and for State's 28, what were the results of your analysis?
So from this, there was an insufficient DNA/data was obtained from the swabs of the driver door behind the handle that is not suitable for comparison to any known standards.
All right, so insufficient on this one, because the last two previous you said were inconclusive. So insufficient is there's not even enough DNA?
Yeah, so this insufficient is just, there's not enough, and it's still very complex to be able to interpret. So inconclusive, there's a little bit more data. Insufficient, there's less data, and that's why I'm not able to interpret it.
All right, and then I'd like to show you State's Exhibit 157, driver's door panel, top edge of storage area swabbed. Do you recognize it? How do you recognize it?
I do recognize it, and it's from the Crime Lab barcode sticker with the case number and exhibit number, and then I hand wrote the Crime Lab's case number, exhibit number, the date I examined it, and my initials.
All right, what were your results for that one?
For this item, there was also insufficient DNA/data that was obtained from the swabs of the top edge of a driver door storage that is not suitable for comparison to any known standards.
All right, and then we get to State's Exhibit 158, DNA swabbing from front driver seat belt. Do you recognize it? How do you recognize it?
I recognize it because it has the Indian River Crime Lab barcode sticker with the case number and exhibit number, and then I hand wrote the Crime Lab's case number, exhibit number, the date I examined it, and there's my initials.
All right, and what were your results as to State's Exhibit 158, the swabs from the seatbelt buckle on the driver's side?
The DNA profile obtained from the swabs from the front driver's seatbelt buckle was consistent with being a mixture of a major and minor component. The male DNA profile obtained from the major component of this mixture matches the DNA profile obtained from the oral standard from Jose Soto-Escalera at 7 locations. Comparisons at the remaining 14 locations were inconclusive due to insufficient DNA quantity and/or quality. For those 7 locations, the frequency with which the major evidence DNA profile is expected to be found in an unrelated individual in the population at large is approximately 1 in 12 billion. No comparisons are possible to the minor component of this mixture profile due to insufficient quantity and/or quality.
All right. What I'd like to ask you about now is State's Exhibit 29. It's a section of carpet from the driver's side of the Dodge Ram. If you can take a look at this exhibit and tell me if you recognize it.
Yes, I do. It has the Crime Lab's barcode sticker with the case number and exhibit number, and then my initial, or I'm sorry, I hand wrote the case number, the exhibit number, the date I examined it, and my initials.
All right, now obviously in all the other exhibits you had swabs. This one is different. Is there any difference in the process of what you do?
So the main difference is for an item like this, it's a larger item, so I kind of look over it. The request was that is there the possibility of blood being on this, so I'm looking for any discoloration, not just red brown stains, but sometimes blood can appear blackish. So I would look for any staining like that, and then I'll perform testing on presumptive testing for blood, and then possibly, if that's positive, I'll do DNA testing.
All right, so on this particular piece of evidence, did you do the chemical testing to determine whether or not there was blood?
Yes, I did.
And what were the results of that test?
The carpet tested positive chemically, indicating the presence of blood.
All right, so now that you know that you have blood, do you do DNA analysis?
Yes, I did.
All right, were you able to get any DNA evidence from that carpet?
Yes, so the DNA profile obtained from the carpet was consistent with being a mixture of a major and a minor component. The female DNA profile obtained from the major component of this mixture matches the DNA profile obtained from the blood standard from Tania Wise at all 21 locations. For those 21 locations, the frequency with which the major evidence DNA profile is expected to be found in an unrelated individual in the population at large is approximately 1 in 87 non-nillion. No comparisons are possible to the minor component of the mixture profile due to insufficient DNA quantity and/or quality.
All right, so when you first started testifying, I think you said you guys look for matches on all 21 loci. Is that right?
So we look at 21 areas. Those are 21 areas we amplify. When I have the data, I try to interpret as many of those areas as I can. Some of them you can't. Whether it's not enough data is present there or that it's too complex. So before I look at any standards, we look and interpret our unknown evidence first. So I first look at my unknown evidence, I determine what areas could be used for comparison, and then I look at standards to compare to.
All right, so say for the one we just did, the seatbelt buckle from the driver's side, that's State's Exhibit 158. You received that first as an unknown, and you determine a major and a minor, and then once you have that profile, then you compare it to our standards.
That's correct.
And when you compared it on that particular item, State's 158, it matched on 7 out of the 21.
There were 7 that were possible to be compared to.
Okay, and then the other 14 you could not.
Correct.
And that produced a number that the frequency was 1 in 12 billion.
Yes.
Okay, so then we go to this one, just so I can comprehend this. So on this one, it was an unknown sample that you found. First you tested it chemically for blood, then there's an unknown standard, and then you compare that to a known standard.
I tested it, I did the chemical test for blood, I did DNA analysis. I have the DNA analysis from this carpet, that's my unknown sample. I interpret the unknown data first, determine what I can interpret, And then once I've done that, then I compare it to any standards that I have.
And on this one, you indicated it matched on all 21.
Because all 21 areas were able to be resolved.
And 87 non-million, it was, the frequency in this one was 1 in 87 non-million. How many zeros is a non-million?
A non-million is 1 followed by 30 zeros. So to get to a non-million is 1 billion times 1 billion times 1 billion times 1,000.
All right. And for this one, the major contributor was Tania Wise.
So she matches that major component.
And is that the highest number that we've heard of since you started testifying?
Yes, I believe so.
I don't have any other questions at this time.
Cross-examination?
Very briefly. Sir, you also did a test on a condom that was found at the scene?
Yes, I did.
Okay, and Mr. Rodriguez, Mr. Soto-Escalera, Mr. Burke, Mr. Giovanni Alvarado, and Eric Alvarado's standards were excluded as contributors to the DNA on that condom. Is that accurate?
Yes, it is.
And you also did DNA testing on a flashlight in this case?
Yes, I did.
Okay, and there was a male DNA profile found on that flashlight. However, Jose Soto-Escalera was excluded as a contributor to the DNA on that flashlight. Is that accurate?
To the major component, yes.
Okay, and when we talk about DNA, it doesn't necessarily have to come from blood, correct?
Correct. So it just comes from cells.
Okay, and in fact, when we take buccal swabs, that's getting what's called an epithelial cell from the inside of your mouth, right?
Yes.
Okay, so epithelial cells meaning like skin cells, correct?
Yes.
Okay, I don't have any further questions.
Any further questions from the state?
Can we approach her?
Sure. We've reached the lunch hour. The lawyers have an issue to attend to that must be done outside of your presence, so we're going to take a little bit of a longer lunch, give you a longer lunch, ask you to come back at 1:45 downstairs to the jury assembly room. Please remember, avoid any extrajudicial information about the case. Don't do any research. Don't talk to anyone. Enjoy your lunch, and we'll see you at 1:45. Please leave your notes on your chairs.
And I could leave all this stuff here, or just,
What's that?
should I? Because that should, that has to be sealed. This is, I think, the one with substitution.
That's an evidence, right?
No, the
That's-
one I have, the one I have, I have
Oh.
one that's in evidence. This is not going in.
I would take all of that with you so we don't accidentally send it back to the jury. And it is going to be sealed anyway, so it makes it easier. All right. Jury has exited. And,
Just, so I've instructed the witness that we're going to be back at 1:45.
okay, he's still on the stand at 1:45?
Still on stand
Okay.
1:45.
All right, we'll see y'all at 1:45. Enjoy your lunch.
Quality, we shout out loud. With justice here, we're feeling proud. Justice is a process.
Well, let's see where we are. It may be much ado about nothing,
Yeah,
depending on where we are.
and I can give you the name of the, I can find out the name of the judge and all that, to
Well,
let you know. Yeah.
no purpose for me to have that unless we're negotiating appearances,
Yes, sir.
which doesn't sound like it. I mean, I don't know if you've talked to, it's a homicide case in Broward, did you say?
Yes, sir.
If you talk to the state attorney that's handling the case and see if they can't fizzle around, because even though it's diluted, you are on the same team, the great
Yeah.
state of Florida team.
Yeah, and I'm gonna try to call her
You know,
tonight, but.
They can negotiate that to what's best for you both.
Yeah. Yeah, I'm gonna try to call her tonight, but I can't make any
What kind of
promises.
witness is it, out of curiosity?
An
'Cause-
interpreter, it's a translator.
Oh, the translator, for the
Rose
garbage
Rosario.
truck? For the garbage truck?
Yes, sir.
Huh. That's interesting that there's another case with a similar issue, unless she's just interpreting.
No, it's the exact same issue.
Really?
Yeah.
Wow.
He specializes in waste truck interpretation.
You're right. Huh. Yeah, because that could leave a big void, though. I'm assuming if the state's calling it witness in custody, that's probably going to take some time, but a few hours probably. But aside from that, I don't know the rest of your case, but in my mind, based on what I've heard, those are the two main pieces, the remaining.
I think we can get through many of the witnesses today. I think we'll still have some more witnesses tomorrow, so just in my view, depending on how quickly or slowly we go today, I think we can at least do a half day tomorrow, and then maybe I'm gonna charge conference or jury instruction, something like that. Tomorrow afternoon, and then start with the final witnesses on Wednesday, or, excuse me, Thursday. But
Charge conference probably can take about 15 minutes.
Yeah.
But I mean, it is what it is, so you just see if you can
Yeah.
see what the situation is in Broward. Maybe it's not as pressing as ours.
Yeah.
You know?
But I would add, I mean, on that.
Because if I call the judge, I can't tell the judge, tell the prosecutor to try the case this way.
Right.
But you can do that on your side. I mean, you can mutually agree as far as order of witnesses and so forth.
Yeah.
They probably haven't given it any thought. They just plan on calling that witness tomorrow, and you're getting the result of, if you call them, they may say, oh, if you called us, we would be able to move that person around, to accommodate your situation. Because if we were able to get this case, the guilt phase, resolved comfortably this week, I think that would be the goal. I mean, we may still be able to get it to the jury on Friday, but we don't want them to be rushed, either side. I think you'd all rather be, the goal would either be to get it to them Thursday afternoon or Friday morning.
Yeah.
Right, because your closing arguments are going to be substantially long. I think it's a complicated case. There's a lot of arguments to be made on both sides. So I'm looking at eating up an entire morning, probably, or afternoon. So it's pretty significant if we waste half a day as far as the effect on getting the case to the jury in a timely way where we're all comfortable with that,
Yeah, I think the upshot is we can still get it done.
If you want to take,
yeah. Off, we can still get it done.
if you want to,
That sounds correct, and I think we're on schedule, even if there be a penalty phase, to get that in next week.
Yeah,
Completed.
I agree.
that part's looking that way to me as well, but even for the flow, if you wanted to take time now, just a pause to call, Broward, the state attorney's office, that's probably worthwhile doing that. And then you find out one way or the other, as soon as you can get an answer.
Yeah, I mean,
Because
she's
you're
in
all
Broward.
kind of in business, you're doing this and they're doing that, and, if there's any way to kind of get a hold of them,
Yeah, I think she's in trial right now.
the prosecutor.
Right.
So maybe after hours, you think?
Yeah, yeah. I've already spoken to her.
Yeah,
no,
okay.
I'm gonna-
All right, so, all right, and then,
Okay. Are you good with this, or?
No.
Do you have an issue? I mean, is this something
We
we
can
can address
talk
right
right
now? Okay, go ahead. Ms. Minton, I think, has an issue with some of the hard drives in this case, so I'll let her address it.
the hard drives.
So the state has just provided me now, Judge, 3 different hard drives that are the total of the Waste Pro videos and audio. Again, for the record, this is a capital case. It is incumbent upon me as defense counsel to view everything that is digital evidence that is meant to go back into evidence, and it becomes evidence of the case, to ensure that it's properly in evidence and that it is what the state purports that it is. There is not sufficient time for me to do that now with the amount of video and audio on those drives. It's not something, I did take a cursory review of the file types on it, but to have listened to it and watched it, I cannot do that in this amount of time. Over and above that, there were redactions that were requested of the, I'm gonna say video and audio as an amalgam, both the video and the audio. There were redactions that were requested, and maybe I improperly assumed this, that the state would redact that from evidence. They have not done that. And so there is extremely prejudicial audio and video on those pieces of evidence that the state seeks to introduce into evidence. The state has conveyed to me that they do not intend to send those items back with the jury. However, they would be improperly allowed into evidence, and I have a legitimate objection to the items. If we could have Mr. Walker step out, Judge, because the rule of sequestration has been invoked, and this goes to another witness's testimony before I say what I'm going to say is on the tape.
Okay, Mr. Walker, if you could step into the hallway for a minute while we sort this out.
Sorry, Judge, I just want to make very clear for the record the impact of the thing that's on those items on the case. So there is a reference on the audio and video from the Waste Pro truck that my client had, or an intimation that my client has committed a previous murder in a different jurisdiction. Obviously, that is extremely prejudicial, both for guilt phase and penalty phase. And I moved to redact those items from the translated transcript that the state had informed us that they were going to seek to introduce into evidence. I again made, I guess, the improper assumption that it would also be redacted from the evidence itself if the state was intending to put those pieces of evidence actually into evidence. The state has now informed me just now that they would like to put the unredacted video and audio into evidence with that information on it that I've just relayed to the court. I have significant problems with that. There are also other audios and videos on the third hard drive that are not translated and transcribed in the transcripts. And so they're in Spanish. I have no idea what they said. So I cannot agree to allow those items to go into evidence when they've neither been translated nor transcribed. I don't know what they are.
Let me digest this for a second here, taking notes. Before I hear the state's response, do I understand correctly what we're talking about on these hard drives is the audio and video, the garbage truck audio video that's been subject of this case for 7 years? That's been the main evidence that when I ask myself, why is this case going to trial in 2025, the answer has always been because we have this audio video on a garbage truck and it needs to go to the FBI, it needs to be enhanced, it needs to be interpreted. It's been the main subject of the case. That's the first question. I'm not saying that, it sounds like I'm saying that in a pointed way, and maybe I am in part, but I'm really kind of scratching my head. That's what we're talking about. So first of all, that's my understanding, that's what we're talking about now?
Yes.
And on these videos and audios, we have three issues that flow from it. One is it's claimed by the defense that they don't know, they have to review it because they're not familiar with it. Number two, there's something on there that was not anticipated. And then number three, there's this issue of the redaction of materials that should be deleted, which came to my attention. I think that I hearken back to the Friday. We had the jury panel filling out questionnaires, and you all were standing right here, and we were litigating something else, and we don't agree that on deletions. And I was thinking, well, they better get it done because the case is 7, 8 years old. We're about to be in the jury trial. That's something normally we sort out pre-trial months, years before, so that we're actually ready to go. That's the way I'm perceiving this situation. I just want to make sure I'm perceiving it correctly before we determine what, if anything, can be done to rectify this. So that's my introduction or questions that I have with regard to this. What's the state's response?
Yeah, so let me
just kind of hone in on the issue. It's not a Richardson violation situation, but it's more of the practical situation. Maybe it is a Richardson violation. I'm just not sure exactly what is going on here, because it just doesn't seem possible that we could be in this posture as I sit here after 2.5 weeks of doing this actual trial, that this is happening. I can't wrap my mind around it. Go ahead, Mr. Richardson.
Right, so there's three issues here, I believe. The first, I'll start with the hard drives that were translated by our translators that will be introduced into evidence, which is exactly what the court's talking about. The first is what's been marked as exhibit number 169, and it is the translation of the August 24th, 2018 Waste Pro video, okay? This video was...
You see, it's a translation that's on a hard drive. In what form is there a translation? Is it someone speaking the translation? Or what are you talking about?
No, I'm sorry. I'll be more specific. It is the videos from the August 24th, 2018 Waste Pro truck that resulted in the transcript. And it is the videos that were relied upon by translator Rose Rosario to arrive at her conclusions that are spelled out in her written translation.
And how is that different from audio and video from the garbage truck? Which is enhanced?
Right.
Okay.
Yes, they've been, these were enhanced prior to being received by Rose Rosario, and she used that enhanced video and audio to arrive at her conclusions in that, for her translation. This particular hard drive, which is States 169, is in discovery, and it has been marked as SAM State Attorney Media 0072, and that has been in discovery since the state's 61st supplement, which I believe is 2023. The transcript of the translation is found on page 2264 to 2278. So
you're talking about an item standing alone, or is that on this hard drive and it's one piece of evidence along with other pieces? I'm not sure.
No, what's on the hard drive are audios and videos that have been enhanced by the FBI that were translated by Rose Rosario. The transcript itself is not on the hard drive, if that's the court's question.
Well, when this all started with you walking up here with a hard drive that had a cord on it, and the objection was asked, I'm just not clear what's on what.
There's three hard drives.
There's three hard drives.
So let me walk you through.
All right.
Okay. So that's the
one
first
of the hard drives is what you just described.
Yes, which is States Exhibit 169. Okay.
Okay.
So let me move on to States Exhibit 170. This is the hard drive that has also been enhanced by the FBI, and it is for the video. It has video and audio for the remainder of the days. So that would be August 21st, August 23rd, August 25th, and August 27th.
So what was
This-
the date of the first one?
The first one was August 24th.
And the second was just other days?
Correct, yeah. So this one was used by FBI translator Norma Campos to arrive at her translation. There is not a written transcript on this one either. Okay? And then that is SAM 000 or 0079, which has been in discovery for more than a year, I think. I don't have the specific supplement on there, but it's been for a while. There is a, hang on, I might have it right here. Yeah. Yeah, I can find that particular date of the supplement, but I believe it's been at least free. It's been in discovery for at least a year. Yeah, I didn't put that down. Hold on. Okay. Then the third hard drive is States Exhibit 183. So, States Exhibit 183 is a compilation of all of the data that was, one, obtained by the St. Lucie County Sheriff's Office, and two, analyzed by the FBI. The analyst's name is David Mingerelli. So,
What type of data?
Video and audio.
That gave rise to the previous two exhibits?
Yes, sir. Right. Yes, sir.
Okay.
So to address the redaction set and all of that data that's contained on that particular drive has all been in discovery for well over a year. Most of it has been in discovery since August 27th of 2018.
So there's no
So-
discovery violation? For Richardson hearing purposes,
No.
there's no discovery violation. Do you agree with that? Let's start there, because for appellate review, that's what they're going to be focused on. Is there a discovery violation first, before we get into whatever else is going on here?
Yes and no. If the state is saying that every audio and video that are on those three pieces of evidence have been translated and transcribed, then no. If, however, there are video and audio on those items, which I believe is what Mr. Richardson told me is on item number 183, that has neither been translated or transcribed and provided to us in English, which is the only language that I speak fluently. This presents a problem for another reason, Judge, and it goes back to my even trying to say is what's on that piece of evidence that we're going to put into evidence. Is it what's in the transcript? I don't know. I don't speak Spanish fluently enough to be able to say that. So I don't know how I, as a lawyer, can properly review it to make proper objections to it other than just what was on the translated transcript. That's what I redacted. I redacted that.
This is reminding me of the issue we had earlier with the summary of the FBI cell phone stuff. Is what's going to happen is the state's going to be moving these, like item number 3, 183, into evidence, which is compilation of all data, but it's not going to be what your witnesses are testifying to, which is we're in a trial where there are allegedly admissions of the defendant saying incriminating things. That's what's relevant here. Is the state just gonna be trying to throw in a whole bunch of statements in Spanish, what's not interpreted, we don't know what it is, and that's what the defense, is that sort of like before, where we had a whole thumb drive of stuff, a whole compilation, it's really not the evidence? Is that what is happening?
No, no.
So I'm still trying to get my sea legs and find out what
Yeah.
the heck is going on.
Yeah, no, I understand. So the point of the 183, which is the compilation, is I have to show how they arrived at their conclusions and the data that they used to arrive at their conclusions. So
Says
I'm
who?
going to.
Says who?
So that we have an intelligent account of
The
everything.
intelligent account would be there's a garbage truck, there's audio, video, the defendant's person on there, and the interpreter hears the Spanish and said, these are the words he's saying.
Yeah.
I don't know what the purpose of 183 is your problem, right?
But that's the main problem, Judge, because I don't know, the state has informed me that it has items on it that have not been translated and transcribed. So as to 183, again, I can't say as an attorney, is it admissible or not? I don't know what it says.
Well, look, I mean, if they're willing to waive any objection to it, then that's fine with me. I won't admit it. But
We
the
should
whole,
waive any objection to what? I don't think that's clear what you're
to
saying.
the introduction of 183 specifically.
Is
how-
183 the part where the defendant says the incriminating things that Mr. Cormier referred to in his opening statement?
They're in there, but they're in there, yes. But the state is going to
Maybe I
rely
don't,
on the.
maybe, I'm sorry, maybe I don't
Yeah.
understand correctly.
Yeah.
169, 169, is that the one that has that's the Spanish video, audio that your interpreter is relying on to say the things that Mr. Cormier said in the opening statement?
From August 24th of 2018.
Right.
That's the one.
Okay.
Yeah.
So where I'm missing the boat is I don't understand why you need to get into all the other stuff. If the main stuff was enhanced, then it's in item number 169. The testimony would be we had audio and video from a garbage truck. It was enhanced. I'm a Spanish interpreter. This is what it says. And you even have something to play for the jury if you wanted
Yeah.
to do that. So that's why
Right,
I'm
but-
still trying to figure, but you all are shaking your head in the affirmative like I'm understanding where you're coming from.
Exactly.
And of course, hopefully this is separate from the issue of whether something needs to be deleted from, that's a separate issue.
Correct.
Right.
So
Yeah. So
the defense position is we can't just willy-nilly say, okay, let's put in 183. It's got all sorts of stuff on there. We may have jurors that speak Spanish or something in there that they're going to interpret. We don't know what's being said. We do have Nancy Hernandez, Rebecca Cedeno. I'm just looking at our jury panel of people that might be fluent in Spanish. Nicole Hurtado, these are Hispanic-sounding names. But aside from that, I mean, you wouldn't put in an audio video in another language. We don't know what's being said on there. I don't know why you think you need to do that. So you said because to establish a foundation to do that, and that's maybe where the rub is here. I'm not saying that. Yeah.
Yeah. So.
That's why I saw Jim. I'm sorry. That's why when you said if they're willing to agree to its admissibility, I thought you're talking about 169 and 170, saying if they're going to object, well, there's no foundation for this. We don't have the original raw data, basically. Is that what you meant by that?
Yeah.
But I don't think they're going to make that objection.
That is not the objection we're making.
Okay. Well, then that totally changes.
Okay,
that-
that's
that
why I go
completely
through
makes
this
things
whole
more efficient. Yeah.
rigmarole.
That's
to
our
get-
concern. We don't know if they're gonna challenge how we got to this point. So then we have to then show, here's what we started with, then the FBI enhanced it, then it went to a translator. So that's why
So
we have.
you're anticipating an objection that's not
Exactly.
coming,
Yes.
right? The
Correct.
objection is not coming.
We're
And I-
objecting to something, Judge. That's not what we're objecting to.
Right. So the foundation for the material exhibits is that there was raw data, it was enhanced, here it is, and here's what's going to the jury. But I understand the defense position, well, that's where you are. Now, on cross-examination, if they were to say, oh, you made this up out of thin air, maybe this is artificial intelligence-generated audio, video, that doesn't look like they're going there, but and that's where you're anticipating they could do that.
Yeah. Right.
In the artificial intelligence division of the FBI. But it's a joke, but
Right.
There are
But-
people that believe a lot of stranger things, but unless
Right.
it's raised, I mean.
Yeah,
you know.
but I prepared the case as if there was going to be objection in order to make sure my evidence came in. But
understand.
if they're not objecting,
Okay.
then that's fine. I got no
Okay,
problem
so
with
that takes care of that issue.
Yes,
Now
yes.
we have,
That's fantastic.
it is fantastic, except I hearken back to the Friday when you were all standing here and you said, well, they have some requested deletions to what's on, I think, is it 169 and 170?
Yes, sir.
And I was hoping and praying that was all going to be sorted out and we didn't get to this point. And its silence I took as a positive sign, but maybe that was too optimistic. But that lingers. Because it's referenced, and you referred to it as someone, either the defendant or Mr. Alvarado, I take it, because those are the two speakers on the audio and video, my understanding, made reference to some other murder, non-existent murder probably, right? Or defendant has been convicted of another murder.
So let me explain to the court the state's position on the redactions. We only received their redaction request, I believe, last week. What we have done, what we've already done, if I understand correctly, is we've already redacted the transcripts, and we agreed to all the redactions.
Mm-hmm.
We've redacted their transcripts, but in order to redact these hard drives is exceedingly difficult. Number one, because they're in Spanish. Number two, because they're difficult to play, just from a pragmatic standpoint.
Mm-hmm.
And it would be very expensive too, because we have to have somebody with the ability to sit down and do that. I think for Rose Rosario, we paid just to
All right,
translate.
so let me just interrupt you there. This may
Yeah.
be a problem that I can solve by dictating the way the evidence goes to the jury.
That's what we're agreeing.
Right.
If we play anything from those videos, we would just show them what it looks like and what it sounds like. We wouldn't play a part where there's only very specific parts that
That's
are
exactly what I
Yeah.
was thinking of, and
we're
not
in
allow that.
agreement to that.
Yeah.
Not allow the actual audio video to go back to the jury, if for no other
Exactly.
reason too. We could have Spanish speakers, and it solves that problem too, so they don't do their own translation. They rely on the evidence from both sides as far as what's being said there.
Yeah. And I just got the redactions back probably 10 minutes ago. I just forwarded
Right.
them to the defense. And what our intentions were that everyone will have a copy of the transcript while it's being read, and they'll be reading it, but it will just be redacted.
Maybe that's overly optimistic. Go ahead, from the defense.
I don't know the efficacy, Judge, or on a, 3851 purposes,
Mhm.
of me agreeing to allow such explosive and prejudicial items into evidence, even if we don't show it to the jury. Because now it's in evidence, can they use it in penalty phase? I don't think that we can,
We're not
like,
using it.
light put it into evidence.
Right. I understand your concern, but no, that should not be a worry. That should not be a worry.
Okay.
And this is sort of like when I give the edited recording instruction to the jury. If you had to play parts of it for either, this is what I was thinking practically, for either side, if you're going to challenge the translation of what you all both agree on is the evidence, you would just have to play that piecemeal. But I can instruct the jury. The reason we're doing that is we don't have a form where we could edit it and do that otherwise. So that's why it's coming to them piecemeal. So it's the same place we get to as if you edited it and I gave the instruction saying, well, there's other stuff on there that you're not hearing. You're not hearing it because it's irrelevant to the case. So that's legally, that's a perfectly comfortable position for us all to be in. Logistically, that's on you, so long as you can live with that. That's where, so long as you can live with that. Because I do hear from at least the state side, I think I heard Mr. Cormier say you're gonna play parts of it just to see that there's a basis that they were actually.
Yeah, we have to show them that, like, we actually
There's-
have something. We didn't just make
Exactly.
it up.
Right. And likewise, I could see on the defense side, because I don't know where the road took you with this, but there was a time when you were both disputing what the actual translation should be at the time. But you would be able to do that.
Yes, sir.
But I would make a clear ruling that the only thing that's actually in evidence on the hard drive is what the basis of the translation is, the transcript, right? I think each side had a transcript too in the case, right? The state had a
Yeah,
transcript.
They had their own
Right.
transcript prepared, which is very
Okay.
similar to ours.
Right, so we covered a lot of ground there. How do we want to shore that up so when we get started with the jury on this, we, A, remember what we did and are able to set it in stone? Is there some way we can set it in stone now and memorialize it? So we don't get into a situation later where you're up here arguing about what we just did here and the understanding of where we're going to go?
It sounds like as far as those three exhibits, if they're not gonna object to us introducing the other two that just have the videos that they relied on the translation, then that part's gonna be fine. I mean, they may have other objections at the time, but it sounds like.
So the ruling would be 183 is, you're not going to put 183 in evidence because you don't need to.
Correct, right.
169, 170 would come into evidence, but only for the purpose. Now, do you have a transcript that's a separate exhibit?
I do.
Okay.
One
Two.
transcript per drive.
The only parts of 169 and 170 that are in evidence actually are those that cover the other item, the actual
It's just
physical.
audio and video, one from the 24th, and then the ones from the 21st, the 23rd, the 24th, or the 25th, and the 27th.
Item is in evidence, but, meaning the hard drive, but what's on the hard drive that is the evidence is what overlaps your transcript.
Yes.
And you're not going to be exposing the jury to parts on the hard drive that are not that, because that is the actual evidence on those.
Agreed.
Right.
Well, it's similar to, I've had other cases where, going back to my analogy to edited instruction, I've had this come up before in 2 decades. We get the last minute and we didn't sort out the addition, so the way to solve that problem is the item is in evidence, it's not going back with the jury, you hear that, which would be the same situation here too, by the way. If they want to hear that portion of 169, 170 that overlaps the transcript, we would bring them out. You all would make sure we're not exposing anything on there that's other than what I just said. Similar type of.
Okay, so there would be an item in evidence, part of it would be shown to a jury, some snippets of the recording. Some of the jurors speak Spanish, and do we expect them to then say, okay, I'm satisfied with that, and they're not gonna ask to see the rest of it? This is a video with purportedly the defendant making a confession. What are we gonna tell them when they say, can we see the rest of the item that's in evidence? No?
Well, that's a separate issue. I'm all ears for that separate issue. That harkens back to the concern about whether they're Spanish-speaking jurors. You know, that's something for, I'm not poo-pooing that issue. That's a separate, significant issue for us to discuss. It may be, this goes back to, I don't know how the show is going to go. Maybe that if you are going to play parts of those just to verify that there really is a basis for this, there really is, that you do it on something that you both agree on, that there's no contest about whatsoever. And if they were to ask to hear more of it, which is really the point that you're broaching, maybe the
items in evidence, right?
right, maybe the answer to that is they can't listen to it. It could be because of the concern that you have, that we're basically telling them, and you both, are you planning on calling an expert to say our interpretation is the better one? Because, let's put it this way. Well, I guess one answer I could give you now is, considering all the ground we've achieved here, we may put that off and see if it actually happens. But if it did happen, I would consider saying they can't do that, because what would be the purpose of it other than to invite them to do their own interpretation?
Right.
Yes, that's true. Conversely, what is the purpose of entering something into evidence if it's held back from the trier of fact?
It's what Mr. Cormier said, just for the purpose that it's in evidence, the jury can't hear the whole thing, but they're establishing the basis that there's a corpus for the interpretation.
And if we had more than 8 days, we would have made a way to redact this, but obviously we can't do it with everything that's been going on
in a short amount of time.
It's functionally impossible with all the witnesses and things that we've been dealing with. So, I mean, I
to
think
your
that the
point
easy-
though, in the last point, the only alternative otherwise would be only to put in evidence the state's actual transcription of that. But that does seem awkward because the jury has no idea of where it came
We
from.
would certainly object to any transcript coming in as anything but an aid to understanding.
Yeah, so I think the place we landed, imperfect as it is, the best possible outcome.
Yeah, right.
Did you want me to shore that up as far as, can I do that at this time, with not having heard the predicates? I guess I can't do that. Y'all will remember what we did here.
Well, I just want to make sure, because this is very important. I had planned that there was going to be an objection, and so I essentially have called enough witnesses to establish almost a super predicate, a way to super authenticate this thing. So I've got everybody in the chain. I've flown people in. They're all in the Gary Morales room right now, waiting to testify. So if the defense position is I can authenticate these only through the translators who will say that these have been enhanced by the FBI and this is what I use to rely upon when I form my conclusions or my opinions, then that's fine. I just need that on the record now before I release people and they go fly back to their different states. And then all of a sudden they withdraw their objection, and I'm stuck.
I'm not sure I understand your concern, but perhaps it's more important that they do.
I don't understand it either, Judge.
I have multiple witnesses who were going to testify as to 183, right? 183 is all the data and videos that were used by multiple analysts to enhance and arrive at the enhanced versions in 169 and 170, okay? If they are waiving their objection to the authentication, then that means I don't have to put in 183, and that means I can release multiple witnesses, and that means I can introduce 169 and 170 through the specific translators who translated each of those respective exhibits. If they're okay with that, then I'm okay with that. We shorten the trial. It makes it easier for everybody. I think it's a win-win for all parties, and we go from there.
I want to speak for the defense, but that's what I heard them to say.
Okay.
However, I would assume you have some witness to say it went to the garbage truck place and retrieved audio and video, because the FBI people didn't do that. So
Yes,
that's part
that's
of
one of my witnesses, right.
Right,
They got-
right. So you could talk about them agreeing to the foundation.
Yeah.
That's part of the foundation too. It is, there's the audio and video. But you're talking about not needing the bigger one to get the little ones in, and that's what I
Right.
heard them to say that very clearly, that we're not going to require that.
I just want to be clear, Judge, because we're talking about two separate things. We're talking about witness testimony and we're talking about 183. I wholeheartedly object to 183 coming in because I do not speak Spanish professionally enough to say what is even on 183 to make logical objections to it. When the state's asking, will I stipulate to a predicate as to 169 and 170, please, I want it to be clear, I'm not going to object to like a chain of custody situation, but I would require, and if the way that I would do it, if I was them, is I put on the witness, like Your Honor said, I got it from the Wasteboro truck, I sent it to the FBI. FBI agent says, I enhanced it using blah, blah, blah software, and then I sent it to the translators. And then, boom, we're at the translators, and we're at 169, 170, and then we're off to the races.
Mm-hmm.
That is what I had expected them to do, not bring in 183 that I don't know what's on that, because no one translated that.
Right.
And to be clear, I just want to be clear, everything that's on 183 has previously been disclosed in a variety of different SAMs and discovery as well. So I want to be very clear about that.
I think we're going backwards now.
Right.
I think the state should go forward. We didn't have a hearing about whether the state is authorized to release its witnesses. You have to do what you do as far as part of this case, as far as whether you want to release them or not. That's up to you, but we had our discussion and it led us there.
And Judge,
Because I can't foresee everything that's going to happen and be responsible if you release the witness that's relevant for some other purpose that I can't see, and that's not my role. But I think the defense spoke pretty clearly to it as far as how we're going forward.
and Judge, if I may, since we're on the topic, I don't want to do it in a half measure. We do have a different objection to the translated transcripts. So I don't know if we want to take that up now.
This is 169, 170.
And then whatever pieces of items of the state's evidence, the two transcripts are that correspond to 169, 170. I didn't hear if they said the numbers of those yet.
The actual
No, we haven't.
transcript.
We're not at that point yet.
Right, so it would go to more specifically the transcripts themselves. And it's a legal argument. So again, I don't know if you want to take it up now or,
It's up to the state. I don't know if anything that we said or determined is contingent on that, or if it's completely separate.
completely separate, but we need to address this second thing before we can even determine if that transcripts come in. If that makes sense.
What is it? Just tell me what your legal issue is. So I can-
Sure, it's Martinez v. State, it's
Yeah.
761 Southern 2nd, 1074, about authenticating transcripts in use in a trial.
It's a Florida Supreme Court case that lays out procedures for trial courts to follow.
And in Martinez, the transcript is in English, and it's still supremely problematic. And the way that the state, I assume, intends to introduce this transcript doesn't even meet the requirements of Martinez. And again, Martinez is in English. So we've added an extra layer of complexity, and I did bring this up before, because it's a translated transcript, which makes it even more difficult. And can I give the case here?
I think I know that case. I've looked at it in the context of our last hearing we had about this. And when I looked at it, frankly, I determined it's not on all fours. It's a different legal situation here. This is a different situation.
Judge, if I may,
Yeah.
just so that the record's clear, and I want to make sure that I lay this out specifically for the record. It's a use of a transcript of the defendant Martinez, and his wife is a participant in the conversation in the transcript, much like Eric Alvarado is a participant in the conversation of the translated transcript in our case. And it starts on page 8, first column, and they talk about the recording itself, and they say to a large extent it's unintelligible and therefore incomplete, which is what we have in this case as well. There's many portions that are unintelligible, even in the FBI enhanced one.
In that case, though, in all cases such as that, there was not an actual interpreter on the stand subject to cross-examination regarding his or her testimony, which is what we're going to have here. And the transcript just memorializes their actual testimony here in court, meaning you could literally not put the transcript in evidence, which would be the other way to go. You don't put the transcript in evidence, you just literally have the witness testify verbatim to what he or she translated. So it's a different issue than there's something that's not clear, and the judge determines which transcript should go to the jury as being accurate. This is a different situation.
What Martinez tells us, and I think what we may be losing sight of here, is the transcript is not the focus, it's the recordings. The jurors their job is to determine the accuracy of the transcript as opposed to what they're hearing on the recordings. How can they do that in this case with the recordings in Spanish? It doesn't matter what the translator says. The jurors have to hear and compare. They can't just take the word of the translator.
They would have their own translator that they present during their case for what they say is not consistent with our translated version.
And that conflicts with what we talked about before. In that case, the state puts in the, as far as, they're not limited to just playing 16970 for parts that you all agree on. They put the whole thing in. And then we're left with the jury. If they speak Spanish, they're able to do that. There's nothing prohibiting them from doing that. It's a different situation than using a court interpreter and telling the jury, there's a witness testifying in Spanish, just rely on what the interpreter said. So if you can't have your cake and eat it too from the defense, you either put the whole thing in and the jury's left, if they speak Spanish, to make their own determination and judge that and judge the credibility of the interpreter, or we go the other way. I'm fine either way.
Judge, the other issue that's
Yeah,
raised
but which
by-
way does the defense, you can't have your cake and eat it too?
The other issue that's raised by the case is, the transcript is not supposed to be a focus of the trial. Now, how is this not going to be a focus of the trial? You already earlier opined, when we started discussing this motion, that this is an extremely critical issue in the trial. This transcript, and as the Martinez case says, the risk is that the jury, who doesn't really know what's on the recording, is going to artificially enhance the importance of the transcript and treat it like evidence.
But that's
a risk in this case, and since it contains what is purported to be the confession of the defendant, it's going to be a focal point of the trial, which is not supposed to be according to the
Because
Florida Supreme Court
the
case.
the interpreter in this case is an expert witness, and the jury can accept or disregard everything that that person says. That's what your case is about. You're going to battle of your interpreters,
And
which is
that-
what makes this case different.
Well, that argument would be true then in any case where a defendant confesses in a different language,
Right.
and we had to have it translated. That argument would be there. And,
Right.
and I know you also, there are supplemental, or there's instructions during trial for the use of transcripts when it's either in, if it's in dispute or if it's not in dispute. And it even addresses, I know some of you speak Spanish in this case, you have to rely on what the translation is.
But those, to me, are red herrings on both sides. That's dealing with a totally different situation. You have a Spanish-speaking witness and an interpreter. It's a different situation here. And I think I mentioned too, previously, I do not want to be commenting on the evidence in this case. You have a dispute between interpreters, or at least you had a dispute. So maybe the situation now is that the defense said they're not calling an interpreter, so you have a battle of the experts.
Judge, can I just read part of?
But it's not helping me because I don't know where we're going factually and what we're going to get to.
Well,
Now
you do have to make an independent interpretation. According to Martinez, the court should
But let's,
also make an
wait,
independent determination.
Mr. Burns, let's lay the foundation. This is what's gonna happen. You're gonna get 169, 170 come into evidence as an enhanced version of the garbage truck audio and video. The audio, right? Then the state's gonna call an expert interpreter to say, I'm an expert interpreter, I listened to it, this is what's being said, and I'm using my expertise and skill to say that. And they're going to go, you could literally have them go point by point. This sentence, the person is saying this. And the transcript of that is verbatim identical to what the testimony of the person was here. So there's really no danger in that. So long as they testify completely consistent with what they've written down, there's no conflict between the transcript and their testimony. The transcript is only there, and my concern with the transcript is they would have to testify to everything that's in the transcript, which goes back to how long we're going to take to try this case. I don't know how long it is. I've asked that question before, but I was told it wasn't that long. But they would have to do that. So the problem would only arise if the witness does not cover all that ground, and now we put a transcript in without them covering that ground to substantiate what's in the transcript. The transcript would really only come into evidence because you all agree it would assist the jury in remembering what the person said if there's a stipulation. If you object to the transcript, I might sustain that and say the witness has to testify verbatim to do that. And you could use the transcript perhaps as a demonstrative aid in your closing argument. Say, he or she said this is what it says.
I want to make sure I understand. I believe I'm correct that the fundamental task of the jury here is to listen to a recording and match it up with a transcript. Here, they can't meaningfully do that. They'll have an expert tell them what's on the recording, do their job for them, and the court is saying, well, if they believe the expert did the job correctly, that's good enough?
How else do you think it would be proved to a jury that doesn't speak Spanish what's being said on an audio, other than to have an expert Spanish-speaking person come in and tell them, I'm an expert in Spanish, and that's what's being said? It's really very simple what's going on here. This is not rocket science to do that. So if you're gonna, if the argument is about whether the transcript comes into evidence on its own, which is really what the focus is, that's an issue. But there's no other way in fairness for either side to prove the contents of a Spanish audio than to have an expert in Spanish come in and say, who's really an expert, say, this is what's being said, and explain it to the jury. And then the jury gets to pass on the expert witness, just like any other expert. Are they skilled enough? Do I reject their testimony? If I accept it, that's what's being said. And the defense is free to call their own person to dispute it, or to cross-examine the person and, and to destroy their credibility by impeaching them. But simple as that. So I suppose the question I would pose to everyone here is, that's the foundation. What I'm telling you is the expert's going to be allowed to come in and say 169, which is enhanced, meaning all the noise was taken out, it's as audible as it can be. That's all that this is in evidence, and it's there, and they're going to testify as far as the contents of it. The transcript is just to assist the jury in understanding their testimony, which it could be problematic if they don't cover all that ground. So we'll take that when we, if you want to object to that, you can, we'll go from there.
I just want to point out one additional thing, Judge. The Martinez court expresses preferences for certain methods of resolving these matters. The chief method of resolving the matter is to have a participant in the conversation authenticate and verify. We have such a person here. We brought him from Connecticut. The state did. It's Eric Alvarado. The state is deliberately eschewing and rejecting the best method of solving this by keeping that witness off the stand to try and work it through the second, what the Martinez court says is a secondary, second best way of having translators come in and say this is what's on there. Why are they not bringing the person who was a participant in the conversation in to tell the jury yes or no? Why are we resorting to a second tier answer?
Well, I mean, that could be a play that I do, but I'm going to authenticate. My intent was to authenticate this without Eric Alvarado.
As the silent witness, as we discussed before.
Correct. Right.
And there's been a change too. Before Mr. Burns said that, I thought Mr. Alvarado was testifying, because all of the arrows were pointing in that direction to me
We would love nothing
previously.
better than to see him in the witness chair.
We did a whole thing about, Mr. Richardson with a jury. Witness comes through the door over here. These are the dynamics of litigation.
Right.
Well, maybe I should be more open-minded to that case, but I've looked at that case. I really have. I don't think it helps me in this particular situation. I think you've boiled it down to the essence of what we have here and go from there. That on the issue of the transcript, I'm not overruling your objection. Let's see where the road takes us with that witness. But it may be, if the defense doesn't agree to the transcript coming in, it may be that the witness is going to have to testify verbatim at the witness could use it to refresh his or her memory as far as the interpretation, but they're going to have to literally interpret it on the stand.
You mean as the recording is playing?
No, just they would have to say they're going to have to
Oh,
speak
yeah.
the transcript.
Yes,
Speak
and that
the
was
transcript.
that was our original
How long is
plan
it?
anyway. Yeah,
How long
yeah.
is it?
So
How long is the recording?
well, exhibit 169,
Yeah.
I think, is 12 or 13 hours.
Oh, we'll
But-
just be here till next year then.
Right.
You'll be here, I won't be here.
Right.
Right.
The translator can't listen to it.
Right. That's why we're not going to play it in its entirety. It's practically impossible. So our intent was we're going to call these translators, and they're going to, we're going to have them testify as to their transcripts, and that will be the evidence. And we could have a second party come in and play both of the participants. So one translator is going to play one participant, and then a police officer is going to come in and play the second participant. And I think it would be probably less than an hour or probably about an hour or so for each of these to come in. That, to put it in a better context for the pagination, I think the transcript for the August 24th, I think is around 16 pages. For the FBI translation for the multi-day, I think it's 44 or 45 pages. So that's what we're talking. We're not talking hours and hours and hours of playing video that nobody can understand. We're talking about people testifying regarding the transcripts.
All right, so why don't we do this? We'll just see where the road takes us. I don't think I can address anything at this juncture until we get there.
Will the court be open to the standing objection that these transcripts will become a focus of the trial improperly as this evidence comes in?
I'm not going to answer that now because I'm not committing to the transcript coming into evidence, period. I'm just allowing the witnesses to testify as to the substance of, they heard what's on 169, 170, and this is what's being said. It's possible it might come in, and you may not even have an objection, because in my world, it's going to completely overlap anyway. You follow me?
Yes.
Yeah.
You may, that may just suit both sides, you know, to do that, but especially if the amount that you said, that could be done.
Yeah.
Speak the transcript, essentially, where they're describing, I listened to this, this is what's being said.
Yes.
For all we know, the jurors are going to be writing it down on their notepads as well. I bet you they will, you know.
Yeah. That was the
Right.
plan.
So the reason I answered that way is you're presuming that I was going to admit the transcript. I may not. Right? Okay. All right, so we've hashed that out. And the irony is we're not even headed into that testimony right now. We're going back into the
We're doing DNA.
DNA.
Yeah.
Right? We're still on the DNA. All right, so do you want to bring in Mr. Walker and resume his testimony? Yes, let's bring in the jury. We'll continue. Jury is present. We continue with the testimony of Mr. Walker.
Good afternoon again, Mr. Walker.
Good afternoon.
All right, just two more items I wanted to ask you about. I want to show you what's been marked for identification. State's Exhibit 167. Earlier in your testimony, we talked about that you take extracts for every single piece of item you examine. Is that right?
Everything that I do DNA testing on has an extract.
Okay, and those are saved for multiple different reasons, one of those being that they could be sent to someone else if they wanted to also test that same item of DNA.
Yes, that's correct.
So I want to show you these two items that are inside of 167. Do you recognize those?
Yes, I do.
How do you recognize those?
So both of the items have the Indian River Crime Lab barcode sticker with the case number and exhibit number, and then I hand wrote what is in this item. So I made this piece of evidence. The extracts went into this manila envelope, and then I've labeled it with the crime lab case number, the sheriff's office case number, the exhibit number, and then what extracts are in both of these different items.
All right, what are the two different extracts? We'll start with the one that has the PR number 322696. What is that extract?
This is an extract of the blood standard from Tania Wise, and also inside is an extract of a reagent blank, and then there's a reagent blank number.
What's a reagent blank?
For every, when I work cases, we actually work them in batches, and I can work up to 13 samples at a time in an extraction set. One of those sample, at least one of those samples has to be what's called a reagent blank, and the purpose of this is, how do I know that the DNA profile I get from a sample is actually from the evidence cutting I put in the tube and not from the chemicals or maybe my pipette tips or things like that? So a reagent blank goes through the exact same process, gets all the same chemicals added to it, but there should be no DNA in it. I don't add any DNA to this. And that will at least be at least one with each extraction set I do.
All right, and then the other item with PR number, this one doesn't, this, we'll go with, they just have this one marked as 296723-1.
So this is the extract of the swabs from the front passenger headrest and an extract of a reagent blank that was from this extraction set with this item.
At this time, the state would move what's been marked for identification into evidence as 167, into evidence as 167.
No objection.
Those will come into evidence at this time without objection.
Thank you, Mr. Walker. I don't have any other questions.
Cross-examination?
No cross-examination, thank you, Judge.
And do you wish to keep Mr. Walker under subpoena or release him, Mr. Caroni?
You can be released.
Any objection to releasing Mr. Walker?
No objection.
Mr. Walker, you are released from your subpoena. You're free to leave or stay as you wish.
Thank you.
Thank you.
William Houseman. State will call William Houseman.
Houseman, if you'll step right up here. Raise your right hand and be sworn, please.
Do you swear or affirm that the evidence you're about to give will be the truth, the whole truth, and nothing but the truth?
I do. You step right this way.
Good afternoon.
Good afternoon.
If you could state your full name and spell your last name for the record.
My name is William Hausman, Hausman.
All right, and how are you currently employed?
I'm currently the president of Prawn Seafoods Incorporated in Miami-Dade County.
All right, now prior to working for that job, did you have a much different job back in October of 2018?
Yes, back then I worked at DNA Labs International for approximately 5 years.
Okay, and if you could tell the jury, what is DNA Labs International? What do they do?
So DNA Labs International does forensic DNA processing.
Okay, and is it a private company? What type of company is it?
It's privately owned.
And does DNA Labs International do testing of DNA at times for law enforcement agencies?
Yes, that's primarily what they do testing for.
All right, what was your job title when you were employed at DNA Labs International?
I was a forensic DNA analyst.
All right. And to become a forensic DNA analyst, what is your background as far as education and training to be able to do that job back when you used to do it?
All right, so I have a bachelor's degree of science from biology at FAU, as well as a master's of science in biology at FAU, as well as going through a training program at DNA Labs International in order to perform DNA analysis procedures.
Okay, and back in 2018, you said you had worked there for 5 years?
Correct.
When you first began your employment with them, were you immediately allowed to work by yourself, or did you have to go through some on-the-job training or any other certifications?
Yeah, so there's a whole training regimen at DNA Labs where you learn new procedures and then you perform competency exams to show that you could perform them accurately.
Okay, and is that something that you went through?
Yes, I did.
Okay, and did you pass the examinations to be able to do DNA analysis?
Yes, I passed all those exams, as well as proficiency exams that were given twice a year by an external company to show that I could perform DNA analysis.
All right. Now, did you receive any items of evidence in reference to this particular case?
I did.
Okay, and do you know what those items were? Do you recall?
Yes. I have 2 items that I see here. One of the items was the extracts of swabbing from the passenger side headrest, as well as the extracts from Tania Wise.
And what I'd like to show you is what's already been marked into or entered into evidence as States Exhibit 167. There's 2 different ones. One is labeled as extracts of swabs from front passenger headrest, and the other being extracts of blood standard from Tania Wise. Is there any markings or identification on there that looks familiar to you?
Yes, I could see DNA Labs International uses their own tape, as well as the initials of one of my coworkers at the time.
Okay. And did you end up doing a DNA analysis in reference to these particular 2 items?
Yes, I did.
What type of analysis were you doing or asked to do in this case?
So what we did is we used a software called StarMix, and what it does is it helps us to evaluate DNA profiles that are mixtures, meaning that there's more than one person contributing to that profile.
And do you look at the standards? I guess, what is the process of how you do it? Do you run the unknown standard and then compare it to a known standard, or how do you do that?
All right. So as far as StarMix, what it does is it weighs 2 propositions against each other, developing a likelihood ratio. So you'll have weighing one proposition against another. So for example, if you have 3 contributors in a DNA profile, it'll weigh the likelihood that one specific contributor, as well as 2 unknowns, is more or less likely than having 3 unknown contributors.
So for then the DNA extract from the extracts of swabs from the front passenger headrest, through StarMix, were you able to determine whether or not there was a mixture of a DNA profile for that exhibit?
Yes, I was.
Okay, and what did it determine, or what did you determine in your analysis?
So the DNA profile obtained from the extract indicates a mixture of at least 3 individuals with at least 1 male contributor, and Tania Esther Weiss could not be ruled out as a possible contributor to this mixed DNA profile.
So the standard that you get from the extract of Tania Wise is compared to the mixture?
Correct.
Okay. And then you had referenced the use of propositions. Were there propositions considered in reference to Tania Wise's including, or I guess being in that mixture of 3 individuals?
Yes, so 2 propositions were considered, or I should say 2 sets of propositions were considered. So the first one is the DNA profile obtained from the extract is approximately 1.1 times more probable if the sample originated from 3 unknown persons than if it originated from Tania Esther Weiss and 2 unknown persons. Therefore, the strength of the support for either proposition cannot be determined, as the likelihood ratio is uninformative. Now, the second set of proposition that I did, the DNA profile obtained from the extract is approximately 4.5 million times more probable if the sample originated from Tania Esther Weiss and 3 unknown persons than if it originated from 4 unknown persons. Therefore, there is extremely strong support that Tania Esther Weiss and 3 unknown persons contributed to this mixed DNA profile, rather than 4 unknown persons.
All right. And when we talk about levels of support in your DNA analysis for mixtures, what is the lowest level of support?
I don't recall.
You don't recall what the lowest?
The lowest one.
What's the highest level of support?
So I'll tell you the highest level of support is extremely strong, which is what we see in this case.
I don't have any other questions for this witness.
Thank you, Judge. So, DNA Labs International, right?
Correct.
That's where you worked?
Correct.
Okay. And I think I heard your testimony to be that extremely, well, I'm sorry, what was the level there that you said?
Extremely strong support.
Extremely strong support that the extract that you received and tested was Tania and 3 other unknown individuals?
Correct.
Okay, got it. And at DLI, you all are capable of testing DNA samples that are pretty old, right?
Correct.
Okay. In fact, I think you all tested a sample that was 22 years old from some gentleman's molar. Do you remember that case?
I don't recall.
Okay, you didn't work on that while you were there?
I've worked on thousands of cases.
Including cold cases, right?
Correct.
Where the DNA is very old.
Correct.
Okay. So you can get DNA from a very old sample?
Yes.
Okay, no further questions.
Any further questions from the state?
There you are.
May Mr. Hausman be released from his subpoena?
Yes, sir.
Any objection to releasing Mr. Hausman?
No objection, Judge.
Thank you, Mr. Hausman. You're released from your subpoena. You're free to stay or leave as you wish. Thank you. And the state's next witness or item of evidence.
Yes, so people say of Florida recall Donna Carmichael.
You previously sworn this session today, so you don't need to be resworn. You're under the same oath previously administered to you. And Mr. Cormier, you may inquire of the witness.
Good afternoon.
How are you?
How are you doing?
I'm good.
Good. So, were you a crime scene investigator that was involved in the search of the defendant's silver Dodge Ram pickup truck?
Yes, sir.
Okay, and how many times was that searched?
One time on consent and 2 times with search warrants.
Okay, what are the dates? I'd like for you to spell out the dates of each search.
May I have permission to look at my notes so I make sure I have the right dates?
Yes.
Okay, on Saturday, August 25th of 2018 was the very first time that I spoke about earlier that we looked at the truck when the truck was in the Detective Bureau parking lot, that we searched or processed it then and took photos.
And that was a consensual search?
Yes, sir.
Okay. Next search, first search warrant, what was the date of that?
The vehicle was towed to the sheriff's office on August 27th. And then on August 31st, which is a Friday, we conducted the first official search warrant with an actual search warrant.
Okay. And then the second search warrant?
Okay, the vehicle was returned on September 10th to the owner, and then the sheriff's office again issued a search warrant for it and received the vehicle on Friday the 21st, and we did the search warrant on Monday, September 24th.
Okay, so if I understand this correctly, the vehicle was in the sheriff's office custody from August 27th through November 10th continuously.
No, through September 10th.
I'm sorry, September 10th continuously.
Yes, sir.
And then it was returned to the defendant on September 10th.
Yes, sir.
And then the vehicle was taken back into sheriff's office custody on September 21st
Yes, sir.
of 2018, correct? And then it was searched on September 24th, is that correct?
Yes, sir.
Okay. And it was searched on August 25th, correct?
Yes, sir.
August 31st,
Yes, sir.
September 24th.
Yes, sir.
Okay, thank you. Okay, now, let me turn your attention to some Waste Pro videos. Did the sheriff's office receive into custody an SD card from a Waste Pro garbage truck on August 27th of 2018?
Yes, sir.
Okay, and did you participate in the collection of data from that Waste Pro garbage truck SD card?
Yes, sir.
Okay, I'm going to show you what has been marked as, I'm sorry, State's Exhibit 169 and also State's Exhibit 170. Have you reviewed the contents of States 169 and 170, both of which are external hard drives?
Yes, sir.
Okay. Is the data from the Waste Pro SD card that was collected on August 27th of 2018, was it placed and provided to David Mingerelli of the FBI in order for him to enhance the audio and video of it?
Yes, sir.
Okay. And is that data used in both of these exhibits?
Yes, sir.
Okay, thank you. And Your Honor, the state moves into evidence 169 and 170.
Any objection?
No further objections, Judge, other than what we previously discussed.
Those items will come into evidence at this time without objection.
And Ms. Carmichael, thank you. That's all the questions that I have.
No, Your Honor, no questions.
May she be released at this time?
She may.
Any objection to releasing Ms. Carmichael from the defense?
Yes.
From the defense, no objection?
No objection, Judge.
Thank you, Ms. Carmichael. You are released from your subpoena. You're free to stay or leave as you wish.
Thank you.
And the state's next witness or item of evidence.
Yes, sir. The people of the state of Florida called David Mingerelli.
case is sworn in.
Do you swear or affirm that the evidence you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
And you may inquire of the witness.
Afternoon.
Afternoon.
Can you state your name for the record and spell your last name, please?
Yes, my name is David J. Mingarelli, spelled Mingarelli.
Okay, and what do you do for a living?
So I am employed with the Federal Bureau of Investigation. I'm a senior digital forensic examiner. I've been employed as such for the last 16 years in the Miami field office.
Okay, and what does a senior digital forensics examiner do for the FBI?
So the major part of my responsibility is collecting, inventorying, processing digital evidence. That might be cell phones, loose media, thumb drives, laptop computers, video surveillance systems, things of that nature. I'm also trained in forensic audio and video processing and enhancement. The last 3 years I've been in charge of the digital video retrieval training program, which is based out of Huntsville, Alabama.
Okay, and go ahead and describe your education and your training and your experience to the jury, please.
So, as part of being a forensic examiner with the FBI, we have internal training and certifications that we are required to take and maintain our levels. There's yearly trainings, yearly proficiency testing programs, outside education, outside vendors provide training for continually evolving technologies.
Okay, and do you have any experience with enhancing audio and video as it relates to evidence that comes into possession from law enforcement?
Yes, I've been trained to process and enhance audio and video as it relates to digital video images and still images.
Okay, and does that, when you say enhance, does that make it easier for a user to understand?
Yes, the primary goal is to enhance the intelligibility or either the viewability or audibility of video recording or audio recording.
Okay, and I want to show you what has been entered into evidence as State's Exhibit number 169, which is a video, or I'm sorry, external hard drive that contains video from August 24th of 2018 from a Waste Pro garbage truck. Are you familiar with that item of evidence?
Yes, I am.
Okay, go ahead and explain to the jury what that is.
So that is the video that I processed initially related to this case. Initially, I was asked to review video footage from a Waste Pro garbage truck for the date of 8/24 of 2018. The video was provided to me. The video, as it came in, was in individual 1-minute pieces for the hourly folders. So each folder was separated by hour for the day. We had 1-minute chunks of video. That video was combined into hourly chunks and then to a daily chunk for 4 cameras. Of primary interest when the request came in was the in-cab audio, which was identified as camera 1. So there was a audio track that went along with the video. So that audio track was extracted from camera 1. It was noted that there was some mechanical noise and what we would identify as broadband noise, which is just environmental type background information or that distracts the user from the ability to listen to a conversation or voices in the cab. So when I examined the video, I noticed primarily the fan. There was a fan running, making a clicking noise. So I was able to isolate a sample of that fan audio noise and use that to basically quiet that fan noise down. So it's basically you take a sample, then you use that sample to eliminate the fan noise or lower the level of the fan noise. So the voice conversation would be a little clearer.
Okay, and can you explain to the jury what a hash value is?
So a hash value is in this case, I provided MD5 hashes on my files. The MD5 hash is a mathematical algorithm. Basically, you pass a data stream. I use a tool that's capable of understanding and generating MD5 hashes. So in my case, I pass my file through an MD5 hash algorithm. It generates a unique fingerprint, if you will. It's a mathematical character representation of the data stream. It's to guarantee that my video files have not been changed in any way since I originally created them. So if I was to take those video files and hash them again, I could verify that those files are intact and have not been altered in any way.
And are there hash values contained in exhibit number 169 from the August 24, 2018 video?
Yes, there are.
Okay. And you said that you were able to enhance the quality of the sound, and you mentioned the fan. Can you walk the jury through the specifics of what you did, what type of software you used, and how you actually carried that out?
Yes. So once I combined the videos from the individual cameras and generated the daily camera, I was able to extract the audio track from camera 1, which is what was of interest in this case. That audio track was then brought into, we use the program called Isotope. It's primarily used for audio and post-production audio. So recording artists, things like that, we use that type of software in order to clean up vocals, remove ambient noises, mechanical hums, things like that. It has other features that remove clicking and hissing. It has a feature called denoise. That denoise feature is what I utilized in this case. I was able to isolate an area of the sound where the fan was clicking. I sampled that audio, and then I used that to lower the level of that fan throughout the rest of the video as that fan was playing, which allows anyone that would listen to that file to focus more on the voices if anyone was speaking in the video. And then that audio track, that enhanced audio track, was added back to a quad camera layout that I created. So using Adobe Premiere, which is Adobe Premiere is a video editing software. I loaded the 4 cameras into a layout so you could see them simultaneously. Since they were in 1-minute chunks, they were very difficult to watch, and that was why the original request had come in. It was very difficult to watch 1-minute chunks of video. So the files were all merged together, and then the audio was cleaned up, added back to that quad view, and then rendered and produced. And that's what I provided on the hard drive.
Okay. And did the methods that you just described ensure the accuracy and the genuineness of the words that were spoken between those 2 individuals in the Waste Pro video? In
Yes,
that
they
video
did.
right there?
Yes.
Okay. And just by you using it, did it actually improve the audio of it and the understandability?
Yes, it did improve the audibility to me.
Okay. Now I'm going to show you what has been introduced into evidence as State's Exhibit 170, which are videos from the dates of August 21st, August 23rd, August 25th, and August 27th of 2018. Do you recognize that exhibit?
Yes, I do.
Okay. Explain to the jury what that is. Thank you.
After I had processed the first video on the 24th, the state's attorney's office requested that I perform the same procedure on these additional dates. And so the difference here is that at this point, the videos, rather than me stitching the original videos as I did on the 24th, so taking those 1-minute pieces and combining them into hourly and then the hourly into a daily for each of the cameras, those videos were provided to me already stitched together. From that point on, I performed the same process. I located the audio track from camera 1, loaded it into Isotope, used the audio filtering that I used before for the fan to lower the noise of the fan, and then took that audio track and merged it back to camera 1, and then rendered a file that contained the 4 camera views with the enhanced audio overlaid.
Okay. And same question, did that process ensure both the accuracy and the genuineness of the words that were spoken between the 2 individuals in the Waste Pro trial?
Yes, it did.
Okay. And did it actually improve the audibility and understandability of it?
Yes, it did.
Okay. State's Exhibit 170, was that particular, or at least a digital copy of it, provided to a translator from the FBI named Norma Campos.
Yes, it was.
Okay, and turning your attention back to State's Exhibit 169, which is the Waste Pro video from August 24th of 2018, was that also provided to a private translator by the name of Rose Rosario?
Yes, it was.
Okay, thank you. Mr. Mingerelli, thank you so much. I have no further questions for you.
Cross-examination. Thank you, Judge. Sir, just so I make sure that I understand, on the days in question, there would be separate folders per hour, and each folder would have 60 sub-files in it, one per minute, right?
If it was an entire hour, then there would be 60. I believe on some of them, the video might have started at 30 minutes or 40 minutes, so you would only have the remainder of the hour. But it was 1 minute chunk of video for each camera separated into hourly folders.
Okay, but some of the files were missing some of the videos. Do you recall that?
The files that were provided by St. Lucie County Sheriff's Office initially, when they had merged the files, once I received them, I realized that I was missing some video. So my understanding was it was just during the merge process. They did not merge properly. So I had made the request back to the St. Lucie County Sheriff's Office, and they had sent corrected files.
Okay, so all of the files didn't get to you the first time, but the second time they did get to you.
That's correct.
Okay, but we didn't convey it properly the first time. Is that accurate?
That's correct.
Okay, no further questions for this witness.
Questions from the state?
No further questions, thank you.
May Mr. Mingarelli be excused from his subpoena at this time?
He may.
Any objection to excusing him from subpoena? From the defense?
Judge, we'd ask that he remain under subpoena momentarily.
Okay, you do remain under subpoena. You may step down. Please be sure if the attorneys, you want a contact number for him to get a hold of him if you want to recall him?
Yes, please.
Okay, thank you. You may step down. And the state's next witness or item of evidence.
Yes, sir. The people of the state of Florida call Adolfo Cavelli.
What was the last name again?
Cavelli,
Cavelli.
C-O-V-E-L-L-I.
Yes, sir.
Do you swear affirm that the evidence you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Over that way, it was.
Yes, sir. Thank you, sir. Yes, sir. Good afternoon.
Can you state your name for the record and spell your last name, please?
Yes, sir. Adolfo Cavelli Jr., C-O-V as in Victor, E-L-L-I.
Okay. And were you working at Waste Pro back in August of 2018?
Yes.
Okay. What did you do for them?
I was the assistant division manager at the end of the career there, but I was basically an operations manager, and I was over the trucks, which was 2 supervisors below me and then the drivers below them, and watch after the operation, the maintenance, and the safety.
Okay. And when you say operations manager, go ahead and just briefly describe what that entails.
Okay, so just in the day-to-day operation, so get there in the morning, drivers check in the morning, make sure we have the vehicles for them and their routes, get them on their routes to go pick up the trash, was over their safety, made sure I met with the route managers to make sure we take care of any issues with driver call-outs, vehicle breakdowns, and items like that, and then make sure we get the garbage picked up every day.
Okay. So if we were to envision a chain of command for Waste Pro in August of 2018, where would you have fallen?
Okay, towards the top. So right above me was the division manager. That was the highest person at the local office, Darlene, and then I was below her as the assistant division manager, which was really just a title change for a pay adjustment while I was transitioning into her position when she retired. I did not make it that far. I left before then, but that was it. So it was the division manager and then myself, I guess you would say number 2 in command, but number 1 over the operations.
Okay. And while you were there at Waste Pro, was there an individual named Jose Soto-Escalera that worked there?
Yes.
Okay, and did he fall below you in the chain of command?
Yes.
Okay, what was his position?
He was a residential driver.
Okay.
Picked up garbage at the houses.
Okay, did he report to you, or was there an intermediary layer in between?
Correct. We had 2 people, so there was route managers or route supervisors. So the chain of command for Jose was myself, then Mike Smith or Michael Smith, and then Jose.
Okay, and did Jose's wife work there as well?
Yes, at the time, Deb Kendall was the other supervisor.
Okay, and where did she fall in the chain of command?
So her and Michael were equivalents. So it was Darlene, then myself, and then Deb and Mike, and then the staff of drivers.
Okay, and did you said, I believe, that Jose Soto-Escalera was a driver, is that right?
Yes.
Okay, what is a prerequisite to becoming a garbage truck driver at Waste Pro?
In order to drive a vehicle for ours, you need a commercial driver's license, a CDL Class B, as in boy, with air brakes.
Okay, gotcha. And if you did not have a commercial driver's license at Waste Pro, were you allowed to drive one of the garbage trucks?
No.
Okay, so you had to have the CDL, is that right?
Correct.
And did Jose Soto-Escalera have a commercial driver's license?
Yes.
Okay. Are you familiar with an individual by the name of Eric Alvarado?
Yes.
Okay, who is Eric Alvarado?
He was a helper for Waste Pro. At the time, he was Jose Soto's helper. I believe they were also related. I'm certain that it was his nephew.
Okay.
Jose was the uncle of Eric Alvarado.
Okay. Did Eric Alvarado have a commercial driver's license?
No.
Okay. So was there ever a circumstance where Eric Alvarado would have been allowed to drive the Waste Pro garbage truck?
No.
Okay. If Eric Alvarado attempted to drive or drove a Waste Pro garbage truck, what would have been the consequence?
Well, if I found out about something that somebody was driving that should not have been driving, they would have been terminated.
Okay. Okay. So swift and immediate consequence.
Yes.
Okay. So let me turn your attention now to the Waste Pro garbage truck. There is a Waste Pro garbage truck, I think named number 1363. Are you familiar with that truck?
Yes. 1363. Yes.
Okay. Who was assigned to that truck in August of 2018?
Jose Soto.
Jose Soto-Escalera?
Yes.
Okay. Was he the driver of that truck?
Yes.
Okay. Was that truck outfitted with a camera system?
Yes.
Okay. And did that camera have an audio system as well?
Yes.
Okay. Can you go ahead and explain to the jury the camera system from Waste Pro garbage truck number 1363?
Yes. The garbage trucks, for those type of garbage trucks, it was called the residential rear load garbage truck. We had 4 cameras and 4 audios. So we had a camera facing out of the front of the truck. So if whoever was driving, it was what the driver was seeing. So there's a camera facing forward. There was also a camera in the cab of the truck, finding out what was going on in the cab along with the audio. There was also a camera and audio in the back of the truck. The back of the garbage truck you call a hopper, and that's where the garbage goes in. So in case someone got hurt back there, whatever, there was a camera back there also for accidents. And then there was a 4th camera on the driver's side looking backwards. So basically what the driver was seeing, if he was looking in the rear view mirror on the driver's side, it's what the camera was saying is what he was seeing from the camera.
Okay. So can you explain to the jury why Waste Pro had this camera system? Why would a garbage truck have all of these cameras?
So we put them in, it's now pretty much standard in garbage trucks and buses, put in for safety measures. Originally put in for, if someone rear-ended us, but, they were going to sue us for getting for us slamming on the brakes, we had the video to prove otherwise. We are also used for measures for improved safety metrics. If a driver was eating while driving, that's a no-no. Talking on the phone while driving, that's a no-no. So it was, again, put in to improve our culture.
Okay. And was there also a microphone located in the Waste Pro garbage truck number 1363?
Yes.
Okay. Explain to the jury where the position of the microphone is.
Okay. So the audio in the video in the cab of the truck was more, if you look at the cab, like it's 100% wide, it was more on the first third, more for the driver, right? So probably like 35% in from the driver's side, so 2/3 from the passenger side, so more on the driver's side.
Have you had occasion to listen to videos and audios from those Waste Pro garbage truck based on your job experience?
Yes.
Okay. Is it easier to hear the person who's seated in the driver's seat versus the passenger seat? Is it equal? Tell the jury about that.
Okay. So it's definitely easier.
With instructions.
Okay. So, and you're familiar not just with this one particular Waste Pro truck, but all of them?
Yes.
Or
at the
most
time-
of them at the time?
When I was working, yes, for the vehicles that were at my location.
Sure. And are they laid out in essentially the same way with cameras as you've previously described and a microphone in the same location as you previously described?
Yes, for all the residential rear loaders, that type of truck, they were all the same.
Okay, okay. And as part of your job, did you have occasion to listen to and watch camera footage and also listen to audio footage from other trucks during the course of your employment?
Quite often.
Okay. And how often would you do that?
I would say it would be regularly, depending on the week, but it could be as easy as someone saying that their garbage was missed, to an accident, to an altercation on a vehicle. I would say easily one time a day, maybe more.
Oh, wow.
But
Okay.
yeah, I would say 5 days a week, 5 times a week, maybe not all once a day, but maybe 3 on one day, 2 on, but 5 a week maybe.
Okay. And based on the placement of those microphones and all of those trucks, is it easier to hear the driver versus the passenger? Is it equal? Tell the jury about that.
Yeah, so on the, again, just speaking about the residential rear loader and those type of vehicles, those cameras, again, were closer to the driver, so the audio, I don't know if the microphone faces a certain way, but it was a lot easier to hear the drivers over the people in the passenger seat.
Okay, thank you. Finally, let me turn your attention back to Jose Soto-Escalera. Describe your relationship with him. Was he an acquaintance? Was he a friend? Was he a good friend? Was this an employment relationship? Tell the jury generally about that.
It was an employee who became an acquaintance. Most of my staff acquaintances, employees.
Okay. Okay. Did you ever have any kind of a beef with him or anything?
No, not. Oh, I'm sorry.
Can we approach
Sure.
it?
All right, with the court's instructions, you can rephrase the question.
And you've never had a problem with the defendant, Jose Soto-Escalera?
No, sir.
Okay. And do you see Mr. Soto-Escalera in the courtroom today?
Yes.
Can you point him out and describe an article of clothing that he's wearing?
Blue shirt, black jacket, and glasses.
Okay. Thank you very much. I have no further questions.
Yes, sir.
Cross-examination?
No cross, Judge.
May Mr. Crivelli be released from the subpoena at this time?
He may.
Can you-
Actually, no.
You want him to remain?
Yes, sir.
Okay. You do remain under subpoena. You may step down, subject to recall by the attorneys.
Yes, sir. Thank you, sir.
You're welcome.
Permission to approach.
Sure. That's actually going to conclude our work with you today. We have some other work to do after you leave. As I told you, we will take as much work as we can outside of your presence before you get here, after you leave, so as to take up as little of your time as is necessary. Please remember, don't do any research about the case. Avoid all media reports of the case. Don't talk to anyone, including your fellow jurors. Please leave your notepads on your chairs. Tomorrow morning, 8:45, same procedure as you followed today. Enjoy your evening, and we'll see you in the morning. We'll be working on the case in the meantime. They have to come into the jury room to listen to that. With regard to a transcript, into the courtroom, right, to avoid that. That's the main purpose of that. The issue about where I think I was wrong and misspoke, and I was actually doing what I was accusing you all of doing, which is confusing that Marshall situation with this. The part about the jurors maybe be able to speak Spanish and doing that, that is what it is. If they have Spanish abilities, they hear it, they're allowed to draw any conclusions, just evidence like any other evidence. So when you're picking the jury, that kind of was built into this case. I'm not sure if it hurts or helps either side. That's not my concern. But so they'll be allowed to do that. The transcript part of it really is just the situation of if you agree. If you do not agree, I would not allow a transcript to come into evidence, because that's equivalent of any expert saying, here's my testimony in the case. Not only did you hear me, but now you have my testimony going back with you. If you wanted to use it as a demonstrative aid, I might be open-minded to it, just to be sure that it actually says exactly what they're testifying to while they testify, like on your screen or something like that. But I think that's pretty clear to me that that's all proper and would resolve any issue in that regard. So some of that came a little bit clear, particularly after Mr. Burns' objection to the transcript, if it were to go that route. And it's legitimate. Just imagine if you call the witness and they only testified to portions of it, and you put the whole transcript in, that's even worse than the scenario. It's not only is it, here's my testimony, it's here's my testimony they didn't even testify to. So with that, and hopefully, while you were talking to me before, and Mr. Richardson said it was like a year long or something, whatever that was like everything that's on those, not the portions that we're relying on were I think you said one is like 44 pages. So, yes. So that's something that you'd have someone, there's no way around that. That's what they have to do. But probably more importantly, the issue about the jurors potentially understanding Spanish, that, like I said, that's built into the case. I think if I were, listening to, I was dissecting what I said, I'm like, what's the problem with that? There is no problem with that. If they speak Spanish, they're able to do that. Versus the scenario, what I was conflating it in with is you have someone who speaks Spanish and we're having a court interpreter. That's where the jury is supposed to rely on the interpreter and not use their Spanish. This is different. This is actual evidence in the case. So,
well, you'll recall we asked the questionnaire about their ability to speak Spanish. So we did know.
Right. And this is South Florida, which is an interesting dynamic too. And the Exhibit A for that would be that your witness is at the moment also in a trial in Broward County with the identical situation. I bet you if you went to all 50 states, maybe only California would have this situation where at the same time within a geographical area you have an expert witness doing the same thing. But I welcome you if you want to make those phone calls and see if we can get that resolved. That would probably help keep the flow. Especially now that I'm told by Mr. Burns that the state is not calling Mr. Alvarado, because that takes a big chunk of time left for our, could be that we have dead time and we're waiting for something. So does that change as far as, let's segue into a whole, where are we going time-wise?
Well, I was just going to say earlier, you might expect this evening or tomorrow morning, when I can get my ducks in a row, to receive a motion to incur costs to get my witnesses here from Connecticut and from Puerto Rico. It's going to be $8,000 to $10,000, I think, transportation and whatnot. And because I think the state's fixing to maybe conclude a little bit earlier, we're running a little bit early.
Sure.
I'm trying to get them here as quickly as we can.
If you do that, as I did with Ms. Minton's motion on the depots, I always have my laptop with me wherever I go. because it's part of the nerd rules of procedure. You must travel everywhere with your
You've been
laptop.
quite remarkable, Judge. Day, night, weekends, we hear from you, yes.
Right, so I'll be able to e-file that whenever I get it, which would facilitate what you need to do.
Yes.
I completely understand the bind that you're in there, and I'll get that done as soon as possible. There was an issue about JAC getting emailed on it and the other thing, but that's really not my concern.
You're gonna have to move faster than Jack, I think, here. Judge.
Yeah, and
Yes.
they've expressed through their email that we don't want to, we're not requesting a hearing on it, so I'll get that done as soon as I see it come through.
Thank you,
So-
Judge.
To follow the same procedure Ms. Minton did, where it went directly to me as well on the email.
Yeah, it's gonna probably come through her office.
Okay.
I was about to say, Judge, she's pretending like he's going to do it. I'm
Yeah, I
sure.
can't really be trusted with that type of stuff, Judge.
All right, anything else from the state for us to address, or?
Yeah, I mean, the only thing, of course, I am going to call the ASA who is responsible with Ms. Rosario in the event that we can't get that worked out. And frankly, I don't think it's, I'm sorry to say, I don't think it's going to work out. I've already spoken to her. That was a few weeks ago, though.
Right.
I was been texting Ms. Rosario here today. So I'm going to try, obviously,
Right.
but I don't know if we can pull it off. So that
I
would mean,
understand.
yeah, that would mean that we would have to take her Thursday. So I would only have just a handful of witnesses
Right.
tomorrow and then Thursday.
So we're on
I
the record.
appreciate you're doing everything you can do. I know of a case, there's somewhere, there is a judge, I think ironically, perhaps in Broward County, who would say, you know, call your next witness, and if you don't call the witness, then they'd like dismiss the case, which is just, I've never done that, I would never do that, it's completely inappropriate. And I appreciate your effort to do that, some of this is built in. I'm just going with, in the best case scenario, you're able to work it out, and we're able to move things along.
Yeah.
If that's how it is, I would even be able to explain to the jury, which you may want to consider, we would be proceeding, except the next witness is, unfortunately has to testify in another trial in another part of the state, so that's the reason for the delay, if you're concerned about that. Otherwise, I would just, not touch that.
Remember Judge Trowbridge?
Oh, I tried many cases before Judge
I
Trowbridge.
would hate to have to tell Judge Trowbridge, I don't have a witness right now, Judge.
Well, that segues very well for when we're off the record. I'll tell you my court TV experience that I had with Judge Trowbridge back when the dinosaurs were roaming the earth. And I think you all will appreciate that story now that we've kind of, the roads have met in that regard. All right, so nothing else to take, and we'll be adjourned until 8:45 in the morning tomorrow. We'll continue. And the good news, too, I think the state would say we're ahead of schedule, basically.
We are very far ahead of
I
schedule.
mean, really, the goal with this case was to resolve the guilt phase this week, one way or the other.
Oh, we're definitely there, I think.
Okay, great. And I had sent you all before we started the evidence, my proposed changes to the jury instructions. I don't know if you got that.
We received it.
Right, so I have that because we're talking about charge conference, there's only like a few issues to discuss. One of the issues on there too is, and you're probably gonna want it, but I don't know. Part of the murder instructions deals with the heat of passion part of it. So I don't know if you want that or not. You're probably gonna say yes. It just seems so. But other than that, the other interesting thing was, as I remember, the charge that says count 1 and count 2 are separate, you should consider them separately, which I think we should take out because they're bound together in this case. So
Right.
something else to think about.
I don't disagree with you, Judge, like logically, but legally, I'm gonna ask to keep that instruction in.
So something for the state to
We're gonna,
contemplate.
we'll sleep on that one.
Yeah.
Yeah, sleep on that one, because my concern there would be confusion of the jury. I don't want to take away the jury's pardon power, but the law has always been that I'm not supposed to instruct them on that. It's no, can't argue it to the jury, but they have it there. And it really wouldn't be eliminating it to avoid that instruction. The problem is I'm inclined to think it's a contradictory thing, and it would just cause confusion. Unless you can think of a scenario that I haven't, which I'm open-minded to. Sometimes there's a scenario that I haven't thought of.
I have a legal argument that I'm going to make that.
There could be
necessitates that.
there could be some factual scenario living. Okay, maybe I'm thinking of the same thing. We'll find out. But so something for the state to ponder too. Right. All right, we'll see you tomorrow then. We'll be adjourned till tomorrow morning.
Thank you, Judge.
Go for it.